All right, we're ready to start the afternoon session, and we have two outstanding authors who've written a lot about this topic, and particularly about President Dwight Eisenhower, who had the enormous task in the 1950s of being the president, both when Brown versus Board of Education was decided in 1954, but more critically, the president during the Little Rock 9 issue in Little Rock, Arkansas in 1957. And to share some of their thoughts about it, is first Jim Newton, who's the editor-at-large of the Los Angeles Times. He's also a member of the Times editorial board and advises on editorial matters and writes and edits for the editorial page and op-ed page. He's been there for over 20 years, and he also spent time working with both the Atlanta Journal-Constitution and as a clerk at the New York Times. He's also a well-known author, and among his books are Justice for All, Earl Warren and the Nation He Made, as well as Eisenhower, The White House Years, two of his classic books. And he'll be speaking to you about Dwight Eisenhower at Little Rock 9 and the town of Little Rock, Arkansas in the 1950s. Please welcome Jim Newton.
Well, thank you all very much. My mother always wanted me to go to Harvard Law School, so her dreams come true today. Thank you all for being here. It's really a great pleasure and an honor to be part of this gathering. Hearing from the Little Rock 9 this morning is something that I will certainly never forget. And I very much look forward to this afternoon and hearing my dear friend Erwin Chemerinsky argue. Before I started, I wanted to thank Professor Ogletree for the invitation to be here today, and also my good friend Dave Nichols for his continuing pursuit of trying to understand Dwight Eisenhower. Dave and I see some aspects of Eisenhower's record on civil rights differently. He'll obviously speak for himself, but I think it's safe to say that his read of Ike is somewhat more positive than mine on this issue. I see Eisenhower on civil rights as fundamentally cautious and blindered about the issue, and yet drawn over and over to the right result by a style of leadership that allowed him to overcome his weaknesses. As a result, I think Dave and I will agree more often than not on the bottom line, that Eisenhower played an important role in advancing civil rights, whatever his motives or impulses. I think we'll also agree that Eisenhower's record is largely contained by three areas: his judicial appointments, what I call his executive actions, principally his support of the Civil Rights Bill in 1957, and his work to desegregate institutions under his control, principally the military. And then finally, of course, the main event that we're here to talk about today, and that's his decision to use troops to enforce desegregation in Little Rock. Together, those moves improved the law, they affirmed the constitutionality of the cause of civil rights, and they made clear eventually that defiance would not be tolerated. All of that is to Eisenhower's undying credit. I would argue, though, that they were not motivated by his embrace of the cause of civil rights or his conviction that desegregation was a matter of national or moral urgency. Rather, they were the result of other forces and impulses. Ike's deference to subordinates in matters where he felt personally unsure, his gradualism, his belief in the fundamental goodness of the American people, black and white, and his absolute understanding of the use of military force and the threat of insurrection. You'll hear in just a minute, because I'm about to tell you, some offensive remarks made by Ike on the subject of race, or an offensive remark. But let me be clear. I do not believe that Eisenhower was racist. He was instead a product of his upbringing, which did little to expose him prior to the presidency or even during the presidency to the struggles of African Americans. He was born in 1890. He was the last president born in the 19th century. He was born in segregated Texas. He was raised in segregated Kansas. He attended segregated West Point, and he rose to the pinnacle of influence in a segregated army. Moreover, he felt a real kinship with the South and identified with white Southerners who feared that desegregating schools would crack the kind of foundations of the culture that they believed so passionately in. Many of Eisenhower's closest associates were Southerners. Even his favorite golf course was Augusta, a segregated golf course. Those influences combined to create in Eisenhower a profound ambivalence about how the country should address discrimination. And it meant that he often sent off some mixed signals. That was readily apparent in an infamous conversation that Eisenhower had with Earl Warren in early 1954. The occasion was one of Ike's stag dinners, so named because only men were invited. We won't get into his discrimination against women, but the event had barely begun before Warren was quite uncomfortable, and that's because Eisenhower seated him close to John W. Davis, who we heard about earlier from Professor Mack. John W. Davis, as he mentioned, was the lawyer for South Carolina in the Brown case and a famous segregationist. That wasn't the worst of it. And by the way, Warren was a sort of prickly character who was very sensitive to violations of propriety. So the fact that he was seated so close to Davis bothered him. And that, unfortunately, was not the worst of it. As the evening continued, Eisenhower at some point took Warren aside, and he gestured to the Southerners in the room and said this: "These are not bad people. All they are concerned about is to see that their sweet little girls are not required to sit in school alongside some big overgrown Negroes." Dave argues in his book that this wasn't an attempt to influence Warren on Brown, and I would agree. It's hard to imagine that such a sort of boorish remark would have any influence on Warren. And I also agree with Dave that the language is probably more offensive to our ear today than it would have been in 1954. But I also think that it's illustrative of Ike's orientation on this issue. He didn't instinctively see civil rights from the perspective of those who were suffering discrimination, but rather from those who were inflicting it. One additional note, Dave notes in his book that Warren may have misquoted Eisenhower, and that's of course possible. There was no other witness to this exchange. Warren put it in his memoir, so he made Ike pay for it. That is possible, as I say, but it doesn't square with the recollection of another participant in this event, and that's Ike's political advisor and Attorney General Herb Brownell. Herb Brownell heard about the exchange later and tried to reconstruct the conversation. What he discovered is that Ike was mad at Warren not for misquoting him, but for violating the terms of these dinners, which is that they were off the record. Eisenhower's diaries and private conversations from the early 1950s also capture his uncertainty and his inner conflict about civil rights, and also about his reservations about those, for those who he felt were pushing the issue too far or too fast. Among other things, he fretted to himself and to close friends that the court might issue an order that the South would simply refuse to obey. And in that, of course, he was partly correct. Here are two diary entries from mid-1953. The first, he writes, "Improvement in race relations is one of those things that will be healthy and sound only if it starts locally. I do not believe that prejudices, even palpably unjustified prejudices, will succumb to compulsion." And a second, he writes, "I believe that federal law imposed upon our states in such a way as to bring about a conflict of the police powers of the states and of the nation would set back the cause of progress in race relations for a long, long time." I would submit that those are not the ruminations of a president who's eager to lead on this issue. Brown, of course, as you all know, and has been mentioned here already today, was decided on or handed down on May 17th of 1954. As written, the Brown opinion famously read and reads, quote, "We conclude that in the field of public education, the doctrine of separate but equal has no place." But when Warren read it from the bench, he interposed a word: "We unanimously conclude." Warren understood the importance of the unanimity in this court. He wrote in his memoirs, "When the word unanimously was spoken, a wave of emotion swept the room. No words or intentional movement, yet a distinct emotional manifestation that defies description." It is safe to say that Eisenhower was not among those who was so moved. He could have welcomed Brown as a triumph of American egalitarianism. He could have welcomed it as applauded the work of his recently appointed Chief Justice, and shared in the responsibility for what many regard as the greatest Supreme Court opinion of the 20th century. He did not. Here was his response, given 2 days later at a press conference. "The Supreme Court has spoken, and I am sworn to uphold the constitutional processes in this country, and I will obey." Well, it's better to obey than disobey, obviously, but that's hardly the ringing endorsement that supporters of Brown, and certainly that Warren felt that they might have wished for. Moreover, Ike's uncertainty about Brown did not abate over time. In 1956, when the Republicans were preparing their platform language for the GOP convention to be held that year in San Francisco, the original draft said that the party and the Republican Party and the Eisenhower administration had, quote unquote, supported the Supreme Court on Brown. Ike rejected that language. In fact, he rejected it so sternly that he refused to go to San Francisco and attend the convention if that language was left in the platform. He also complained to Brownell, his attorney general at the time, that he felt Brown had set back the cause of civil rights. Curiously, he also insisted that the administration had never taken a stand on the issue. That's sort of weirdly untrue, because the Justice Department had, in fact, filed a brief that he had seen in support of desegregation. So the floor managers, faced with his rejection, tried again. This time they substituted language saying that the administration concurred in the ruling, and that was still not good enough for Eisenhower. Eventually, they settled on a passage saying that the administration accepts the ruling in Brown. With that, Ike said he could go, and off to San Francisco we went. And yet, it is the same Eisenhower who was capable of that crude remark to Warren, and the same Eisenhower who rejected the platform language, who was in some measure responsible for Brown. It is, after all, he who named Warren to the court, and it was Warren who not only wrote Brown, but delivered the unanimous court behind it, an outcome that would have been virtually inconceivable under his predecessor, Chief Justice Fred Vinson. So how is it possible that a man capable of that remark and capable of his position on the platform could also be responsible for the appointment of justices and judges who earnestly and sometimes quite bravely implemented Brown? My answer to that is in two parts. First is that Ike was a complicated man. No one knows better than Dave and I. Every time you think you've got something firm about Eisenhower, he surprises you with something else. And he was genuinely conflicted on this issue. And second is that his style of management inclined him toward trusting gifted subordinates. And in this case, he had the gifted subordinate to guide him through the confusion on this issue was Herb Brownell, who I've mentioned a couple of times. Brownell, for those of you who don't know, was a lawyer, an influential political figure in mid-century Republican politics. He had guided Tom Dewey's campaigns for president. Was a leading strategist for the moderate center of the Republican Party that Ike identified with, and that sadly doesn't really exist anymore today. Brownell also ran Eisenhower's campaign, and Eisenhower trusted him implicitly on matters of domestic politics, in part because Eisenhower was conscious of his own shortcomings there. His whole background really was in diplomatic and military affairs. It was Brownell who identified judicial candidates for Ike, usually operating under a fairly broad mandate. And it was natural that Brownell would be an advocate for Warren. Warren had been Tom Dewey's running mate in 1948. Brownell knew him quite well, respected him greatly. And Eisenhower himself grew fond of the governor. Warren was governor of California at the time, after the GOP convention in 1952, when Ike beat him for the nomination, the Republican nomination. Eisenhower, of course, went on to win the general election that year. And considered Warren first for a position in his cabinet, ultimately completed his cabinet without naming Warren. But he instead told Warren, shortly after the election, before he was inaugurated, that Warren would get the first vacancy on the U.S. Supreme Court. When the vacancy occurred, however, Ike hesitated and didn't immediately offer to him. He had not intended to offer Warren the chief justiceship and had not expected that that would be the first vacancy. He even sounded out John Foster Dulles on the possibility of joining the court, an occasion that would have been of great and horrid consequence for the country. But Brownell urged him to stick with his promise to Warren, and eventually, of course, Warren did get the nomination that year. I should also emphasize that Brownell was not unsupervised by Ike when it came to spotting judicial candidates, as he vetted them. He did so with instructions from the president each time. After Warren, for instance, Eisenhower said he no longer wanted nominees who lacked bench experience. And when it came to filling Sherman Minton's seat in 1956, and it was an election year, Eisenhower specifically told Brownell he wanted four things: a conservative, a sitting judge, preferably a Democrat, and definitely a Catholic. He got William Brennan, which is to say he got roughly 3 out of 4 of those. One final note on Ike's Supreme Court appointees or nominees. They were quite varied. Warren and Brennan, of course, properly thought of as liberals, one a Republican, one a Democrat. John Harlan and Potter Stewart, appropriately thought of as conservatives. Only Charles Whitaker, I think, really wasn't up to the job, and he didn't last very long. And yet, every single one of those justices voted to uphold and extend Brown every single time it came before them. And moreover, the quality of those justices was matched by the quality of the district and appellate court judges who as I said earlier, really had to carry out the hard work of Brown of deciding what fulfilled the obligation of all deliberate speed. And they too, of course, were placed there by Eisenhower. So I think it's fair to ask, what's the difference if Eisenhower advanced the cause of civil rights because he believed strongly in it, or because he followed the lead of others? Indeed, I think that's part of Dave's premise, and it's valid. If Judge Ike, by his actions, not his words, and you come away with a much more positive appraisal of his leadership on this issue. But the answer, I think, is that sometimes Ike's ambivalence had consequences. Indeed, one of the most profound consequences of his ambiguity on civil rights contributed to the Little Rock crisis that we're here today discussing. At a news conference on July 17th of 1957, just a few months before the Little Rock crisis, Eisenhower was specifically asked whether he had the authority to use military force to integrate schools. This is his answer. Well, first of all, lawyers have differed about some of these authorities of which you speak, but I have been informed by various lawyers that the power does exist. But I want to say this. I can't imagine any set of circumstances that would ever induce me to send federal troops into a federal court and into any area to enforce the orders of a federal court, because I believe that the common sense of America will never require it. You have to sort of cull through his syntax there, which was famously sort of dense. But what he seemed to be saying is that he believed he had a power that he would not use. That gave room for speculation that Southerners who resisted integration might be able to get away with it. And one who clearly took advantage of that was Orville Faubus. Now, you all have heard a much more vivid description of the Little Rock crisis this morning than I can possibly offer you. But let me just sketch out a few of the facts on it because I think they help illustrate where Eisenhower was coming from on it. For Faubus, thwarting desegregation was a political necessity. He was running for re-election. He had a challenge from his right. He had been accused of being sort of soft in previous elections. In fact, he was accused of being a communist in one election, although many people don't know it. Orville Eugene Faubus, his full name being Orville Eugene Faubus, the Eugene in that his namesake was Eugene Debs, the famous American socialist. So Faubus, recognizing this political challenge, mobilized the National Guard and directed it to block the students. We are so lucky to have some with us today. And with that, Ike was faced with a direct challenge to his authority as commander-in-chief. If a governor could use federal troops, National Guard, to thwart the orders of a federal court, then the rule of law as we know it was coming to an end. And I should note, Ike may not have been a great student at West Point. He wasn't. But he knew the history of the Civil War, and he understood the relationship between state and federal governments to a T. He also gravely grasped the implications of sending federal troops into a southern city. And so first, before doing so, he tried to negotiate his way through this crisis. Over Brownell's objections, incidentally, Eisenhower invited Faubus to join him at the military base, the naval base at Newport, Rhode Island, where he and Mamie were vacationing. Mamie was recovering from a hysterectomy. The two men talked informally at first. Faubus talked about having served under General Patton in World War II. I talked about having served over General Patton in World War II. And then they settled down to business. Faubus proposed that Ike essentially back off, that he grant a cooling off period, and that he give Faubus the use of federal marshals to help control order. This must have struck Ike as rich. We were in this situation because Faubus had used the National Guard to block the orders of court. Now he wanted federal marshals too. So instead, Ike countered with his own proposal that the Guard remain in place, but that Faubus change its orders from blocking the students from entering school to escorting and protecting them. He concluded with a very stern reminder to the governor. If the state defied the federal government, the state would lose. Well, Faubus left there initially seeming to have agreed, and then he dawdled and played for time, until finally on the night of September 20th, in the face of a clear order from the federal court not to obstruct, Faubus removed the National Guard from the streets of Little Rock. That was a Friday evening, and the nation spent a restless weekend. On Monday, the mob turned, as we all know, on those brave boys and girls, and it prevented them from entering school. Little Rock seethed, and throughout the day, Ike shuttled back and forth between Washington and Little Rock. He ended the day on a relaxing note, though he and Mamie watched a movie. Get this, Song of the South. By Tuesday, again, as we were all reminded this morning, the situation had deteriorated even further. The mayor begged for help, the mayor of Little Rock begged for help, and Eisenhower at that point realized he had no choice. He dispatched the 101st Airborne, the same units he had used to soften the beaches at Normandy, and those soldiers did, in fact, restore order. The integration of Little Rock High School, or Central High School in Little Rock, as we all know, was a triumphant moment and a noble struggle. And Eisenhower played an instrumental and indispensable role in achieving it. But was he motivated by the ambitions of that struggle? I don't think so. Indeed, for what motivated Ike in this issue, we can really turn directly to his own words. Here's what he said from the White House at 9 p.m. on September 24th, 1957. As you know, the Supreme Court of the United States has decided that separate public educational facilities for the races are inherently unequal, and therefore compulsory school segregation laws are unconstitutional. Our personal opinions about the decision have no bearing on the matter of enforcement. The responsibility and authority of the Supreme Court to interpret the Constitution are very clear. Local federal courts were instructed by the Supreme Court to issue such orders and decrees as might be necessary to achieve admission to public schools without regard to race and with all deliberate speed, end quote. Ike's position then at Little Rock was essentially the same as his position in the immediate aftermath of Brown. It was not that he welcomed desegregation, but that his duty was to obey and enforce the law. For Faubus, Little Rock was about race. For Eisenhower, Little Rock was about power. But let me conclude, though, with an observation. Recognizing that Ike was conflicted about this issue only makes him more interesting and in some ways no less admirable. Here was a man who did not have instinctive sympathy for the urgency of civil rights, and yet nevertheless gave it force and support because he knew his duty demanded it, and he refused to shirk his duty. John Eisenhower, Ike's son, met with me several years ago in a long session to talk about his dad, and he emphasized to me then that his father neither sought nor won the presidency because he was interested in advancing social change. He was not a social reformer, John told me. He was a commander-in-chief. He also was a compassionate leader and a highly shrewd manager. He wanted to move slowly on civil rights, but when action was required, he deployed it with skill and resolve. The result is something really fairly extraordinary in American history. In the end, Dwight Eisenhower managed to create a presidency whose record on the preeminent social issue of its day was better than the instincts of the president himself. That is no small feat. It's why he does deserve our respect, despite his limitations. I thank you all very much for listening. I look forward to Dave's presentation.
Well done.
Thanks so much, Jim. I'm very pleased to now introduce our next presenter, Dr. Dave Nichols. Dr. Nichols is a presidential historian and a leading authority on the presidency of Dwight Eisenhower. His award-winning book on President Eisenhower and civil rights is entitled A Matter of Justice, Eisenhower and the Beginning of the Civil Rights Revolution. A native of Kansas, he received his PhD in history from the College of William and Mary, and his dissertation entitled Lincoln and the Indians, Civil War, Policy and Politics was reissued as a paperback book by the University of Illinois Press in 2000 and republished in 2012 this year. He's spoken across the nation about the Eisenhower presidency and launched the publication of his book on Eisenhower and civil rights at the Clinton Presidential Library in 2007. He is a distinguished scholar and teacher and a wonderful person with us today. Please welcome Dr. David Nichols.
Professor Ogletree, thank you so much. I always hate mistakes. Those of you who are able to get the handout that's out there, there's an error on about the second paragraph, and it should say after the Brown decision, Ike appointed 4 pro-desegregation. Yeah, proofreading is an awful thing. Goodness. So it's good to be with you, distinguished friends, colleagues, especially those of you of the Little Rock 9. And Ken Black for your work on those wonderful lawyers. I write about stubborn old white men, stubborn old white male politicians. You know, but I have an African-American daughter, and she and I know that you are the real war heroes for us. And I know that, and in his own way, Ike knew it too. And Jim Newton, who wrote a review of my Suez book, an author would kill for. He was wonderful. A dear man, and I appreciate his willingness to engage in dialogue on this. Now, I'm going to take this rickety plane of mine back to the 1950s, and we need to check 3 pieces of baggage at the gate. And the first is my personal baggage, and it's election time, so I suppose I must assert that I am not a shill for the Republican Party. I have a son named for John Kennedy. I marched with Martin Luther King, and I was a delegate to the Battle of Chicago in 1968. Does that take care of that? And neither am I shill for the Democrats, nor a lawyer, nor a legal expert. And now it reminds me, wasn't it Ross Perot's vice presidential candidate who said, "Who am I? Why am I here?" I'm here because I'm a scholar who tries never to put a phrase in a book that is not rooted in a document or in compelling circumstantial evidence. Now, the second piece of baggage that we need to check is our love affair with the 1960s. Folks, to quote Joe Biden, folks, the 50s were not the 60s. In January 1953, there was no mass movement in the streets. The Brown decision had not been made. Civil rights legislation had not been passed. And JFK and LBJ had not gotten religion on the subject yet. In January 1953, to give you a sense of what it was like, a black visitor from Boston would have not been able to get a hotel room, a meal, attend a movie, find a restroom, or get a drink of water in downtown Washington, D.C. in January 1953. It's a long story, but thanks to Dwight Eisenhower, by the end of that year, that was mostly all gone. And the Eisenhower legacy has been severely distorted by our obsession with looking at it through the prism of the 1960s. But the final piece of the baggage is Ike's personal style, and Jim is quite on target about a lot of that. Yes, civil rights was not Eisenhower's comfort zone, especially compared to foreign policy. He did not understand, I think, how brutal it was to be black in America, not in his gut. He did not owe his election to African Americans. And yes, he leaned on Herbert Brownell for advice, and in many respects was not as liberal as Brownell. I'll grant all that. But Ike had a powerful commitment to equality before the law. And a key we must understand is how Eisenhower made decisions, how he gave marching orders to his subordinates. Ike, the boss, was not the smiling grandfather that he paraded in public. He would grill his subordinates about every conceivable issue related to a big decision. And the quotes that historians often cite to prove Eisenhower's lack of commitment to civil rights are largely cherry-picked out of that decision-making context. With Eisenhower, you must not just look at what he said in the middle of a decision-making process, but you need to look at where he lands. That explains much of the complications that Jim was talking about. Yes, Ike disdained the bully pulpit. He had not won the war in Europe by making speeches. But that does not justify the conclusion. Well, if he didn't say it, he didn't do it. Whatever Eisenhower said or did not say, that is no excuse for my profession ignoring what he did. And here's what he did, much too briefly. It's better on the handout if you don't want to listen. Eisenhower desegregated the District of Columbia, something Harry Truman had not done. And as a candidate on September 8th, 1952, Eisenhower pledged to eliminate, quote, the last vestige of segregation in the nation's capital. And he largely kept that promise. Now, the textbooks tell us that Harry Truman desegregated the armed forces. Yes, Truman issued an executive order in 1948, but 4 years later, most combat units were still segregated. Thanks to Eisenhower, by October 30th, 1954, a year and a half after he came into office, not a single segregated combat unit remained. And the VA southern bases, and other agencies had been desegregated. Ike deserves a place with Truman in the textbooks because together they made the armed forces the most integrated institution in American life. Ike appointed the first black executive to the White House, E. Frederick Morrill. Yes, the Morrill appointment looks like tokenism to us modern people, but no previous president had done that. He made other important pro-civil rights appointments, above all, Jim and I agree, above all, Herbert Brownell, I think one of the great attorney generals in our history. Eisenhower proposed, fought for, signed, and implemented the first civil rights legislation in 82 years. Weak as it was, the 1957 Civil Rights Act laid the groundwork for the watershed legislation of 1964-65, which, by the way, as a post-presidency, Eisenhower actively urged Republicans to support, and he gave Republican candidate Barry Goldwater fits behind the scenes on his negative vote. The myth, and this is wading into deep water, the myth is that the Civil Rights Act of 1957 was Lyndon Johnson's triumph. In fact, Johnson voted consistently with the segregationists to gut that bill. Johnson did not propose the legislation. I'm saying something very obvious. He did not. Eisenhower did. And it included Part 3, which gave the Attorney General authority to sue in federal court to protect civil rights, including school desegregation. But Richard Russell and Johnson torpedoed that provision, and they forced Ike to choose between dropping Part 3 or no bill at all. And Eisenhower, I think, wisely chose to break the legislative law's jam, a decision that was endorsed by Martin Luther King. But at that moment, the Southern segregationists in the Congress lost their historic stranglehold on civil rights legislation. And thanks to Eisenhower, more Republicans than the Democrats voted for the bill. The 60 positive votes, 37 of them Republican. That's LBJ's master of the Senate stuff. Anyway, but this is a law school, so let's discuss Eisenhower's judicial appointments for a few moments. Now, let's be clear. I don't mean to be too facetious, but Earl Warren did not appoint himself. Ike did it. Herbert Brownell recalled that promising Warren the first vacancy in the court was indeed Eisenhower's idea, not his. And yes, Jim's right. When the Chief Justice position came open, Ike hesitated. But I repeat, don't judge Eisenhower by what he says during the process of decision-making. Look at where he lands. And he landed on Earl Warren, a man he knew, and I'll say this again, despite all you've read otherwise, a man he knew was liberal on race. Eisenhower's implementation of that decision was breathtaking. He announced the nomination on Wednesday, September 30th, made it a recess appointment, and Warren took his seat the following Monday, October 5th. As a result, Warren was free to begin immediately working on Brown, although Warren was not confirmed by the Senate until March 1st, 1954. Now, true, Herbert Brownell recommended 3 more nominees to the Supreme Court, but I do not find any evidence that Eisenhower was casual about them. He resisted enormous pressure to nominate a Southerner for the first opening after the Brown decision, and instead he nominated John Marshall Harlan II. Yes, a Brownell recommendation. John Marshall Harlan II was the namesake and the grandson of the only negative vote in 1896 in Plessy v. Ferguson. And you don't think the segregationists didn't know what that meant? They got the message. And when Harlan's nomination was initially derailed, Eisenhower resubmitted it again and again. Once Ike made a judicial nomination, he refused to back off. He fought for them. You can duplicate that with nomination after nomination. The next recess appointment was William Brennan, hardly a right-winger, and Charles Evans Whitaker and Potter Stewart, Ike's third recess appointment, made after William Rogers succeeded Brownell as Attorney General. Keep that in mind. Ike championed Potter Stewart's appointment during a 4-month struggle with the Senate. And Stewart is the guy who said to the Senate Judiciary Committee, if you think I am dedicated to overturning Brown, I will tell you I am not. Eisenhower refused to appoint known segregationists to the lower courts, but John F. Kennedy, my son's namesake, when he took office, appointed segregationists right and left. Eisenhower appointed courageous judges to the Fourth and Fifth Circuits in the South. A great example is Frank Johnson. Frank Johnson spent 44 years on the bench. In 1956, Johnson struck down segregated seating in the Montgomery, Alabama buses after Rosa Parks refused to go to the back of the bus. And in 1965, Johnson cleared the way for Martin Luther King's entourage to march from Selma to Montgomery, spurring the passage of the 1965 Voting Rights Act. Herbert Brownell, in his memoirs, recalled that, and I quote, President Eisenhower took an unusual interest in judicial appointments, unquote. As Ike wrote to his brother Edgar, and this is on the back of your handout, the lawyers of this country, this is Ike, the lawyers of this country have not come to understand that I do not consider federal judgeships as included in the list of appointments subject to patronage, unquote. Eisenhower and Brownell actually depoliticized the judicial nomination process by removing it from the White House where Truman had kept it, and by instituting American Bar Association approval of nominees. But this was not, I repeat, not Eisenhower taking himself out of the decision-making process. The evidence for that is what happened after Herb Brownell left office. No change. When William Rogers succeeded Brownell as Attorney General, General Eisenhower warned him in writing, and this is on the back of the handout, quote, I have always taken a deep personal interest in the appointment of federal judges. For this reason, I should like that before you submit a formal nomination for signature, you drop in to confer with me about the matter. When Rogers failed to follow through, Ike formally reprimanded him with a letter and a conference in January of 1959. And the biggest humiliation of all for Rogers was pretty chummy with Jim Eastland, the Mississippi chair of the Judiciary Committee. And they worked out a deal where they would add 25 judgeships that would do all the civil rights cases they really needed. They worked out a deal. And to do that, and Eisenhower had finally agreed that half of the 25, that's 12 and a half, I don't know how you do that, but anyway, half of them could be Democrats. But he put a condition on it, that they, regardless of party, needed to be, quote, the best qualified candidates. And Lyndon Johnson and Jim Eastland knew what that meant. No segregationists. And they killed the deal. And Rogers had to crowfish out of it because the president had, in effect, vetoed it. I know that for a fact. I talked with Lawrence Walsh personally, who helped negotiate that deal. I assure you that's what happened. Finally, in 1957, when Governor Oglethorpe deployed the National Guard in Little Rock, Eisenhower sent the 101st Airborne into Little Rock. Little Rock is the tip of the Eisenhower judicial iceberg. The court order to desegregate Central High School was issued by Judge Ronald Davies. Now, who do you think appointed Ronald Davies? Sure, you bet. Now, the charge that Eisenhower acted indecisively in Little Rock is absurd on the face of it. What is indecisive, folks, about sending troops sporting fixed bayonets into a former Confederate state? Of course he wanted to avoid it. What president wouldn't want to avoid it? It is equally inaccurate to say that Eisenhower had no choice but to send in troops. If keeping order in Little Rock was the issue, Governor Faubus and the Arkansas National Guard would have kept order, but they would have not desegregated the school. In fact, Eisenhower decided up front about the possibility of using troops. And on September 4th, 1957, stick with me on this, Faubus deploys the National Guard on the 3rd. On the 4th, Herbert Brownell makes a statement to the press in which he ticks off all the things the president could do. And then the last one he says is, quote, the president could use federal troops or the National Guard units of any state to enforce the court order. This statement was issued explicitly with the approval of the president 1 day after Faubus sent the Guard in. And on September 5th, the next day, in response to a telegram from Faubus, Eisenhower wired him, quote, the federal Constitution will be upheld by me by every legal means at my command. And Herb Brownell and Dwight Eisenhower had long ago agreed that that legal means included troops. And in fact, the July 17th episode that Jim talks about in the news conference, that's what Eisenhower said. He had the authority. So is the glass half full or half empty on that? If he says, I have the authority, I just can't imagine any circumstances where somebody will be so dumb as to make me do it. There's an implied threat. The segregationists hung on every word about this guy. They understood that subtlety was his thing, but not when he was in charge. Senator Herman Talmadge said it so well. Eisenhower, he said, after all, was a general. A professional politician might have backed down, but not Ike. When he called in federal troops to desegregate the school, we knew he meant business. And what Eisenhower said in his speech after sending troops, well, we're running short on time. He said just what Jim said. He swore pretty much the same thing he said on right after the Brown decision. But those words, Eisenhower saying that whenever necessary, the means at the president's command, he quotes those exact same words on August 20th, 1958, after the 8th Circuit Court rules on Cooper v. Era. He quotes those exact words to say, in effect, again, to the Southerners, he would use troops again if he needed to. In fact, he said, I feel exactly as I did a year ago. And after the Cooper v. Aaron Supreme Court decision, he says this, and this quote's on the back of your handout. We must never forget that the rights of all of us depend upon respect for the lawfully determined rights of each of us. As one nation, we must assure to all our people, whatever their color or creed, the enjoyment of their constitutional rights and the full measure of the law's protection. We must be faithful to our constitutional ideals and go forward in good faith with the unremitting task of translating them into reality. So if somebody wants to tell you Eisenhower never spoke out about Supreme Court decisions, include this one, not just May 17th, 54. He was a first-term politician. You know what those guys do. They trim a lot. I mean, that happens. Not now, of course. But anyway, the main sources of the Eisenhower controversy, forgive me, I'm taking a little longer than I intended, but we need to get to those. Before Brown, Eisenhower desegregated dozens of federally controlled schools for military dependents in the South. The Brown decision was announced on May 17th, 1954. The next day, he ordered the commissioners of the District of Columbia to develop a plan for desegregation that would be a model for the nation, and they had one in 1 week. Does anything happen in 1 week in Washington now? You think they didn't think he meant business? 2 days later, then he makes the statement that Jim quoted. The Supreme Court has spoken, and I've sworn to uphold the constitutional processes in the country, and I will obey. Now, it's hardly a ringing moral endorsement, but I've increasingly come to treat this statement as a soldierly statement of duty. And if so, it means more to a soldier. And I have challenged, and I'll challenge you, people all across the United States to give me one statement of positive praise for the Brown decision in the months following, not 10 years later, in the months following, by Harry Truman, John F. Kennedy, or Lyndon B. Johnson. If you can find one, let me know. I've searched endlessly. I've not been able to find it. The only thing I find is people find statements in the 60s that read backward. Eisenhower, why didn't he say more publicly? I think he honestly believed in separation of powers and that the president shouldn't comment on Supreme Court decisions. I think he believed that Southerners would respond more to a call for obeying the law. But I have to talk for just a few moments about the stag dinner story, because that's the linchpin. And Jim read it to you. I'm not going to read those awful words to you again. You know, they are awful. I can't excuse them. You know, people generally assume, and my profession has assumed, that if the Chief Justice said it, it must be true. Now, look, nothing I say here or we say here can diminish Earl Warren's stature. His judicial achievements are monumental, especially the unanimous ruling in Brown. But this story has generally dominated. So many of my colleagues have said, well, if he said that, nothing else matters. I'm sorry, that's not adequate. In the 1950s, white men often said such things. That's true. But why did Warren decide to highlight this story? Obviously, to paint Eisenhower as a racist. But more important, to claim that Eisenhower was lobbying him against overturning Plessy v. Ferguson. And please note that in his memoirs, Warren gives no credit to Eisenhower for the 4 other appointments to his own bench or to his appointments to the federal courts. And when Eisenhower sent troops into Little Rock, Earl Warren said nothing. In my view, Warren's contention that Ike was lobbying against Brown is simply not credible. Why not? Because we can document, this is not in the book. If I were new edition, it will be. We can document that Eisenhower and Herbert Brownell had agreed on the tenor of the government's brief to Brown months earlier. And Brownell, by the way, was in attendance at that dinner. It was not a big bunch of people. It was about 11 people. So they were all within hearing range. You know, it was a stag dinner. What can I say? It was the 50s. They had agreed. On August 19th, 1953, Eisenhower and Brownell agreed that Brownell would present a brief calling for the overthrow of Plessy v. Ferguson. Yes, typically Ike raised every single issue he could think of, and so again, historians cherry pick out of that conversation, but you have to look at where he lands, and Brownell himself says he landed on saying, go ahead. And at his November 16th, 1953 news conference, just before Brownell was to submit his brief to the court, a reporter asked the president if he was going to consult with the attorney general about his brief, and he said, indeed, if he consults with him, he said, indeed I do. We confer regularly, and this subject comes along with others constantly. Brownell submitted it on November 27th, and on December 2nd, Brownell informed the president that Chief Justice Warren had told him that the brief was outstanding. I think that's proof positive that Ike knew the content of the brief, and probably Brownell got his word from Warren because they were pretty close. And that means that Warren knew that Ike knew. And finally, in a much misunderstood conversation, on January 25th, 1954, Brownell called Ike to tell him in confidence that he had heard, almost surely from Warren, that the court might decide the constitutionality of Plessy this spring, but put off remedies for the next year. Remedies meant enforcement. It was not about the constitutional issue. If you read any book that tells you otherwise, it's not correct. Eisenhower and Brownell already assumed that Plessy would be struck down. And Eisenhower, by the way, did an extraordinary thing and personally edited the Brown II brief that the government presented. We know that for sure. He personally edited it. And he left in place, out of that editing, a requirement, if the government's case had been taken by the court, a requirement that the courts give school districts 90 days to present a desegregation plan. Now, the court didn't do that, as you know. You know what they did? They said desegregation could proceed with, what's the phrase? All deliberate speed. And Brownell and Eisenhower were never happy with that. Eisenhower signed off on and edited a brief that was much tougher. And by February 8th, the date of the stag dinner, in other words, Dwight Eisenhower and Herb Brownell had long since agreed on their stance before the court. And so Brownell, it just is not credible that Ike was lobbying him on that matter. So that all too briefly is the case for Eisenhower. He was not a saint. nor did he deeply understand how much oppressed African Americans needed a word of encouragement from their president. I wish he'd done that. He didn't. But I'll say to you again, there's no excuse for ignoring what he did. This was the 1950s, not the 1960s. And I will say to you that in the 1950s, Dwight Eisenhower was demonstrably more progressive on civil rights than Harry Truman, Lyndon Johnson, or John F. Kennedy. Ike later put it in an interview. He said, if there was anything good done, they mostly want to prove that it was somebody else that did it, and that I went along as a passenger. Well, Dwight Eisenhower was no passenger. Most of the time, he was in the driver's seat. Thank you.
Thank you so much, Dr. Nichols. You can see there's a different point of view in history about Dwight Eisenhower, and I think we've been incredibly well educated. We have time for a couple of questions. The microphones are coming our way. If you want to ask Chuck Walker, I see you standing up, ask a question. Take the microphone. They're bringing them down now.
Thank you so much. As a son of a Tuskegee Airman, I really am fascinated by this refutation of the desegregation of the armed forces and of Eisenhower's statements. And I know that I walked by a church and I saw a quote by him saying something about, it had nothing to do with civil rights, but it said something about for every gun that's shot and every rocket that's launched.
Yeah, it's the April 16th, 1953 speech, A Chance for Peace. It's a great speech.
Yeah, that shocked me too. Just like this other quote you have in here. The Honorable Dwight Eisenhower has done more to eliminate, this is the third quote you have here.
That's Adam Clayton Powell.
Yeah.
Yes.
I'm going to ask you, what was the basis of Adam Clayton Powell's quote? What inspired Adam Clayton Powell to say that particular?
Well, Adam Clayton Powell, of course, is a very controversial figure that I won't try to get into, but it was basically in reaction to the desegregation of the District of Columbia and the desegregation of the armed forces. He was very assertive about that. When Ike first came into office, he complained that after Truman had finished 4 years, 2/3 of the Army units were still segregated. 60% of the Navy blacks just worked in the galley and that kind of thing, had no serious jobs, and he was active about that. And Eisenhower went after it. And by the way, I don't think there's a lot of evidence. I think Herbert Brownell was, again, an advisor in this, particularly in the District of Columbia, but I don't think there's extraordinary evidence that what happened with the armed forces that Brownell was deeply involved with. This was something that Ike was committed to before he and Brownell, in fact, talked about it in Paris in 1952.
I think it would be helpful if we could have at least a couple of sentences about the role of Warren in creating Brown and Cooper. I guess Cooper was not unanimous like Brown, but
Yeah, it was.
it would help. It was?
Yes, it
Oh.
was.
It was.
In fact,
Well,
the
if-
justices all signed it individually.
If we could have it would help provide context for us all if we could have at least a couple of sentences about why Warren made such a contribution to these two wonderful decisions. And perhaps we could also have some comment about the famous story about Eisenhower when asked what were the dumbest decisions he ever made, and naming the choice of Warren as one of them. Thank you.
Yeah, I think I can take that. I'll do it as quickly as I can. The pre-Warren records of the court are a little confusing, but there is the strong suggestion that there were at least 3 justices prepared to uphold segregation before Warren came to the court. Reed, Vinson, and Jackson, right? And arguably Frankfurter. The reason the records are a little hard to track. Well, let me explain, and then you can have the last word, Justice. Some of the conference notes were kept by William Douglas. William Douglas counted both Frankfurter and Jackson as likely votes to uphold segregation, not on segregation per se, but on concern for what we would today call the activism of the decision. The problem with that is that Douglas detested both Frankfurter and Jackson, especially Frankfurter. So his notes really have to be regarded as suspect. I hope that gets to your concern.
Give him the microphone.
Yes. Right. Yes, right. The fact that Vincent died, and Frankfurter was terribly concerned about the court being locked up on this and having a divided court, and he is famously, although perhaps apocryphally, quoted as having said when Vincent died that it was the first solid evidence that I ever had of the existence of God. So that suggests that he probably wasn't in the other camp. But in any case, it was clearly a divided court that Warren inherited. And Warren went about not only writing a decision that the other justices could join, but also quite personally working on the justices to secure their support. So I do think that Warren has to be credited with the unanimous court in Brown. I think it's, as I said in my remarks earlier, inconceivable that that court would have been unanimous without him. And let's reflect on the fact that that unanimous court meant something that a divided court wouldn't have meant. It meant that together we had Stanley Reed, just to depart for one moment, Stanley Reed was a sufficiently ardent segregationist that he, a few years before Brown, had refused to attend the Christmas party of the court if black pages were to be invited. And Warren secured his support for Brown. So that's no small achievement. And it clearly signaled a kind of moral position as well as a legal position for the court to be united on it. And I really do think that Warren singularly deserves the credit for that.
I'd like to comment on the other item they raised. The legend that's out there is that Ike said appointing Earl Warren was the worst damn fool mistake he ever made. It's out on the internet. It's there forever. I've had people contact me from all over the country trying to document it. The closest documentation you have is an interview, allegedly, and I'll explain why it's allegedly, by Stephen Ambrose with Eisenhower. Whether you know or not, Stephen Ambrose's work is heavily discredited now because we know that he invented interviews with Eisenhower that in fact never took place. And Stephen Ambrose is the one who said Eisenhower was no leader at all in civil rights. And so having said that, there was bad blood between these two guys. Okay? I think it was over presidential politics. We don't have time to explore that. So buy the book, read chapter 5. Okay?
Yeah, I would just add that I've looked high and low for the same quote, and there is no credible source for it. By the way, it's often quoted as the two worst mistakes I ever made are sitting on the Supreme Court, and they're Brennan and Warren, meaning Brennan and Warren. So the fact that there's variants of it also, I think, should cause people to regard it with some suspicion.
But Eisenhower was upset, I think Jim would agree, on some of the rulings on criminal law and communism, that he was not happy with some of that.
He was clearly disappointed in both Brennan and Warren.
Yeah.
Great. All right. Please thank Jim Newton and David Nichols. We will, in just a minute, have the argument in the case of Chad Oglethorpe versus Harris Wald Township. And that's no, different Chaz. Yeah. So I asked all the judges, go put on your robes, please. They'll be excused, and the lawyers as well, excused now. And we'll start in just a minute or two. And they'll line you up to come in. As we're making this transition, we're going to ask as well that Larry Watson will do a special tribute to Little Rock 9 and those who are here for Brown versus the Board of Education and all the other legends. Please welcome once again music impresario Larry Watson.
We decided we're going to do some flat-foot singing just off the color. One of the things to pay tribute to so many of our warriors and heroes that are here this afternoon. And so with these young artists who are in the process of becoming the veteran artists of tomorrow, I put them on the spot because that's what improvisation is all about. So we're going to start with this. Ain't gonna let nobody warriors. Mr. Harold Fontaine, town and we will sing for him. So, for our great guests here today, who trailblazed this movement, we know that you are all winners, and we're going to do this piece for you that talks about, in the midst of living under one of the most horrendous systems that gave us hope and optimism for a better day, we do this song called I Was Born to Read.
Yes, I'm born to win. 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 I've been lost and found, turned upside down. Yeah, yeah, yeah. I've been cast aside and been despised. But I'm Daniel in the lion's den. Daniel in the lion's den. Jones in the belly of the whale. How can I cannot fail. No, no, no. 'Cause I'm born to win. Yes, I'm born to win. Oh, yes, I'm born to win. You know I'm born to win. I've been cast aside and deep despised. Yeah, yeah, yeah. I've been accused and then abused. Yeah, yeah, yeah. But the stone that the builder refused, the stone will be the next cornerstone. Yeah, yeah. No, I cannot fail. No, no, no. Yes, I'm born to win. Born to win. Born to win. Oh, yes. Born to win.
And we'd like to end. There's a special song I wrote, and I had my brothers and sisters from Arkansas and many others in mind when I wrote this song. Because none of us would be anything without those great parents, aunts and uncles, mothers and fathers, who sacrificed so much for us all to sit in these hollow halls at Harvard today and listen to people analyze and give great credence to folks that just oftentimes said my feet is tired but my soul is rested and did what they had to do. So we do this last piece. It's called Kings and Queens. It goes like this.
All of my life I've maintained my integrity. Bought a house and some land, something that God will always see. But the sacrifice was worth it. I've got the dignity. Each of us must really believe we are a part of this great legacy. We've come from a line of kings and queens, and nothing is worth our dignity. You know, mama and daddy worked their fingers to the bone. Bought a house and some land, something that they could call their own. Yet the sacrifice was worth it. They planted the seed. Each of us must really believe. Oh, yes, that we are a part of the legacy. We come from a line of kings and queens.
Well, I think we're ready for this great court, but once again, thank Larry Watson, who has 1,000 things to do and always is here. I will now, first of all, let me thank, it's in the program, but all the people from the Charles Hillman Houston Institute for Race and Justice and other people here at Harvard who did an incredible job to put the program together, the meals, the contact all of the panelists, the judges, et cetera, and just have been incredible. Those folks who are part of the staff, the fellows and researchers, Dr. Susan Eaton, Kelly Garvin, David Harris, Laura McNeil, Derek Northington, Granier O'Neill, Ernest Owens, Zanabu Ramallah, and Joanne DeWald have done an incredible amount of work to make this successful. I'd ask you to join me in thanking the staff for a great job. A number of you have asked, what about civil rights today? What's happening? We're going to talk about 2012. In fact, Gina Chirino somewhere right there, she actually has some materials downstairs in the lobby that everyone, Gina, stand up so people know who you are. She worked with us for many years in the education department and has some about the current civil rights movement as well. You get a chance to look at that. And again, the last minute to get a chance to see the books from the authors. Now, the way this is being designed, this is not Cooper versus Aaron, but this is a hypothetical case. It's called Chad Oglethorpe, not me, Chad Oglethorpe versus the Harris Wald Township, and about what's happened since Brown and Cooper versus Aaron. This is a difficult case in the sense it's not a traditional way that the Supreme Court would get a case, but this is the Supreme Court that will be hearing it. And it's also different because we have 10 justices rather than 9. And you'll get a chance to hear from each of them and their comments during the course of the presentation. What is unusual about it is they decide where we are today on trying to achieve integration. Is that they will take a look at these facts, and instead of going behind to deliberate and critique it, they will actually have their deliberations right here in front of you. So you'll hear what they have to say about the issues today and how they have an impact on what we're trying to do. And we have 2 very distinguished litigators who are representing each side, and the petitioners represented by Dean Erwin Chemerinsky, who's the Dean of the University of California Irvine Law School and a 1978 graduate of Harvard Law School, my classmate. Representing Chad Oglethorpe, please welcome Dean Erwin Chemerinsky. Arguing and representing the Harris Wald Township is a dear friend. She came in to pinch hit on very short notice, and she's agreed to do it. She's been teaching here at Harvard this past year after spending a wonderful career as a district court judge here in Massachusetts, making a number of timely and important decisions, and has been really one of the leading authorities on sentencing law in the country, and is prepared to argue this case today, and I'm very happy to have her here. I told her the one rule: she cannot object to what the judges say. She's not the judge today, she's a lawyer today, but a wonderful judge. Please welcome Judge Nancy Gertner. What a distinguished group of judges we have today, and they are from all around the country, from circuits all around the country, and they've done a tremendous job. Introducing them by experience, I'm not using the word age or even seniority, but experience in terms of in the court or service as a chief judge of their respective courts. First, please welcome from the U.S. Court of Appeals for the D.C. Circuit, the Honorable Harry T. Edwards. Second, welcome the Chief Judge from the United States Court of Appeals for the Third Circuit, the Honorable Theodore McKee. Third, please welcome to the United States Court of Appeals for the Fourth Circuit, Judge Roger Gregory. Fourth, please welcome the Senior Judge from the United States Court of Appeals for the Second Circuit, the Honorable Barrington Parker, Jr. Next, please welcome from the United States Court of Appeals for the Fourth Circuit, the Honorable Allison Duncan. Next, please welcome from the United States Court of Appeals for the Second Circuit, the Honorable Raymond Loyer. Next, please welcome from the United States Court of Appeals for the Fourth Circuit, the Honorable James A. Wynn, Jr. Next, please welcome from the United States Court of Appeals for the Fifth Circuit, the Honorable James E. Graves. Next, please welcome from the United States Court of Appeals for the Sixth Circuit, the Honorable Bernice Donald. Finally, please welcome who will be the Chief Justice for this court today and the Justice from the United States Supreme Court, Justice formerly from the First Circuit District Court of Appeals, Chief Judge there, a professor at Harvard Law School for many years, and a wonderful man. Please welcome Chief Justice, in this case, Steve Breyer. Please welcome all of our judges. If you're going to take pictures, take them right now before they sit down. Get your shots in quickly. Each side will have 30 minutes that will be determined by Chief Justice Chief Justice Breyer. And he will call the case to order, and I hope that you will learn a lot from what's about to happen in these next few minutes. Chief Justice Breyer, turn it over to you.
We'll hear argument in the case of Oglethorpe versus Harris Wald Township.
Thank you. Good afternoon. Chief Justice Breyer, and may it please the court. 58 years after this court's decision in Brown versus Board of Education, American public schools are increasingly separate and unequal. Demographic realities and the decisions of this court make racial integration an impossibility in most American cities. However, equal educational opportunity remains a constitutional imperative. As to the case before you today, I wish to make two arguments.
But
First,
you said racial equal opportunity in education is a constitutional imperative?
yes, Your Honor.
And where are you getting that from? Education is not a fundamental right.
This court in Brown versus Board of Education said that today, education is the most important function of government.
But it's not a fundamental right.
No, in Rodriguez versus San Antonio Board of Education, this court said that education is not a fundamental right. But even subsequent to Rodriguez, in Plyler versus Doe in 1982, this court again recognized the fundamental importance of education without using the label fundamental right.
Children.
Pardon?
As pertaining to illegal alien children and how government could spend its money for them.
That was the holding, Your Honor, in Plyler, but the language of the majority opinion talked about the fundamental importance of education for all children. And that, of course, was what Brown versus Board of Education was about. And as to the case that's before the court this afternoon, I wish to make two arguments. First, the desegregation plan adopted by the Harris Wald School District violates equal protection under this court's decisions in Swan versus Charlotte Mecklenburg Board of Education and parents involved in community schools for Seattle Schools number 1. Second, the disparities in funding within the Harris Wald School District violate equal protection, including under this court's decision in San Antonio Board of Education versus Rodriguez.
If you're right, what does that do to the fundamental interest that you just spoke about in terms of equal educational opportunity? How do we achieve it?
Your Honor, at the very least, what I'm saying in this case is disparities in funding within a school district violate equal protection. And the record here shows that there are substantial disparities in funding between the Martin Luther King School and the Pebble Creek School. And the intra-district disparities are clearly a denial of equal protection.
Okay, but the question remains, how do we achieve the importance of educational equality that you began your presentation with?
This court should hold that the disparity in funding within this school system deny equal protection, and order an equalization of funding within the schools within this district.
Wait a minute. You're the complaining party here. So it's your burden to convince us that the plan put in by the school district is unconstitutional. And I'm trying to understand what's your foundation. Are you saying merely because race was among the factors considered? And I'm assuming if that's your argument, you're looking to concerned parents or parents involved. And parents involved was a racial balancing case, and that's what bothered the plurality there. This isn't a racial balancing case, is it?
Your Honor, I have two separate reasons why the desegregation plan is unconstitutional. One goes, as you say, to the court's decision in parents involved in community schools for session number 1. Their 5 justices on the court said that the government may use race as a factor in assigning students to schools only if it can show that no race-neutral alternative can succeed. If you look at page 8 of the record, it specifically says that race is a factor in assigning students within the Harris-Wald School District. Under this court's decision, that can be done only if there's a showing that no race-neutral alternatives succeed. There is no showing by the school district in this case, no such finding by the lower court, which makes the plan
Wait,
unconstitutional.
there are 5 justices? Can I just follow you? There are 5 justices in parents involved that say you cannot use race as a consideration?
Yes, Your Honor. Chief Justice Roberts' opinion, in a part that was the majority opinion, Justice Kennedy concurred in part and concurred in the judgment part, but this is the part he concurred in, said that the government may use race as a factor in assigning students to schools only if it can show that no race-neutral alternative can achieve diversity.
Okay, so let me give you the part of Justice Kennedy. Let's assuming we do a count vote thing. Justice Kennedy said diversity is a compelling educational goal. Attendance zones may be redrawn. School districts may act to avoid racial isolation. So now if you put Justice Kennedy's notions with the 4 dissenters, what does that do with your position?
Your Honor, there were 5 justices in parents involved to say that diversity is a compelling interest. We do not challenge that diversity is a compelling interest. However, if you'll notice what you just read from Justice Kennedy, it does not include assigning students to schools based on race, absent a showing that there's no race-neutral alternative that can succeed. And what the school district would have to show here in assigning students based on race is that there's no race-neutral alternative that can achieve diversity.
Why
Is there
aren't you
anything in
asking
the
us-
record that shows that the school system considered race-neutral alternatives? Is there anything in the record that would show that?
There is nothing in the record here, Your Honor, which is why, under this court's decision and parents involved, it's impermissible. And as I said to Justice Edwards, I do want to point out there's a second reason why the school district plan is unconstitutional. In Swan versus Charlotte-Mecklenburg Board of Education, this court said that busing is permissible for reasonable distances, and now I'm quoting the court, so long as not hinder the education of students. The 2 students in this case, Chad Oglethorpe and David McNeil, were each bused 90 minutes each way. The facts in the record show it did interfere with the educational opportunity of the students. This is not a reasonable amount of busing. And so on that basis, under Swan, the desegregation order is also unconstitutional.
But you have said you agree that there is, that the plan, you're arguing that the plan is unconstitutional, but you want an order from this court equalizing funding?
That's correct, Your Honor.
And what is your basis for that? What would be your basis, predicate for that order, for such an
Equal
order?
protection, Your Honor. In Rodriguez, this court dealt with whether or not inter-district disparities violate the Constitution.
And how is that analytically distinct from the situation we have here? Why should it matter in terms of framing a remedy?
This is an intra-district disparity, and it makes an enormous difference. In Rodriguez, and a year later in Milliken versus Bradley, this court talked about the importance of respect for school district lines and about the ability to have inter-district remedies only if there is an inter-district violation. This is an intra-district disparity. Nothing in Rodriguez would be the contrary, that such an intra-district disparity in funding violates equal protection.
But we said in Antonio that it's not just how much money is spent, but how the money is spent. And it sounds to me like you're asking us to enter an order that would take us back to separate but equal, saying we can't fix the fact that these school districts are separate, spend the money to make them equal, even though we have said there's no way to measure equality by the amount of spending.
No, Your Honor. What Brown versus Board of Education was addressing, state laws that required separation of students. That's not what we're dealing with here. What we're dealing with here is a reality of demographics. When you look at, for example, Dallas, where the students are 4% white, or Chicago, where the school system is 8% white, or Los Angeles was 8.4% white, or Boston, where it's 13% white. There is simply nothing a school district can do or court can do to achieve racial integration.
Let me ask you one thing, so I understand your position. I won't say one thing because I don't want to limit myself. Could the school district have used a lottery here?
Yes, Your Honor.
Okay, and the results would have been essentially the same.
Well, Your Honor, if the
Because
lottery
we
was-
have one largely all black, one largely all white, and a mix. And so the odds are likely we're going to end up with the mix that you're saying they cannot achieve doing it the way they did it.
Your Honor, two things. First, if the lottery involved busing students 90 minutes, I believe that would be inconsistent with this court's decision in Swan.
But that's not a constitutional violation to make a child stay on a bus a long period of time. It may be inconvenient and may even violate state law, but it's not a constitutional violation.
No, but Your Honor, busing is a remedy. In this court in Swan, at 402 U.S., at pages 30,
No,
31.
no, wait, stay with the lottery.
Okay,
It's
I'll
a
go back to the lottery.
And we get essentially the same results. And we now have a diverse school. That's okay, right? Even though the kids are being bused 90 minutes.
That's true, because race is then not used. However,
Well,
if-
wait, is race used here? I thought they did this by neighborhood.
No, Your Honor.
Did they say race?
Yes,
or did
Your
they
Honor.
say
On
neighborhood?
page 8, towards the bottom of the page of the record, it specifically says that one of the factors that's used in assigning students is race. And that's the tension between what the school district did here and what this court said in parents involved in community schools is permissible. And Justice Edwards, to go back to your question, there is a huge difference between a lottery in assigning students and the use of race in assigning students under this court's decision in parents involved.
Let me ask you,
The school district said we're using a lottery because we know we will get the racial diversity that we want.
Your Honor, that would be different, because this court has said when the government acts with the purpose and the effect of a racial classification, that's to be treated that way. So if the government creates the lottery with the purpose of achieving racial diversity and with the effect of achieving racial diversity, that's the same as a racial classification, going back to this court's decision in Washington versus Davis in 1976.
let me ask you this. Would you view the equalization of funding to be a race-neutral alternative?
Yes, Your Honor, by
Why is
definition.
that not present in every case then? Such that if that's a race-neutral alternative, then every case is obviated because it's available, the equalization of funding.
Your Honor, there are two separate considerations. One that you point to, the equalization of funding. And if the same amount is spent on each student's education, black or white, by definition, that's race neutral. The other question is one of racial integration. And thus, it's our position that while racial integration cannot be constitutionally achieved, at least on the record in this case, equalization of educational funding can and should be achieved on the record in this case.
Why shouldn't we?
Are we just to assume that equalization of expenditures will somehow result in a parity in performance? Or
Quality of opportunity.
Is there anything in the record that establishes that?
No, Your Honor. At the very least, I'd say that poor children should have the same chance to be disappointed by the spending of money on education that wealthy children have always had. But, Your Honor, there are many studies that indicate that there's a relationship between educational expenditures and educational achievement. In fact, I think common sense for all of us who are parents would confirm that. All of us would rather that our children be educated in a class with 20 students and one teacher than with 45 students in one teacher, and that does come down to educational expenditures.
Counsel, should we adopt Justice Douglas's concurrence in Keyes, and should we be making a difference between de facto and de jure segregation? Because you've talked about using funding to achieve a particular purpose, but isn't it required that there be some state imposition? And are you asking us to simply conflate de facto and de jure segregation to achieve a particular result?
As I said to Justice Wynn's question, I do think it's important to distinguish between the disparity in funding and the lack of racial integration. As the disparity in funding, it is de jure in this case. It is a school board appropriating different money for these two different schools in the same district. In terms of the racial separation in this district, it would be de facto. And this court has drawn a distinction between intentional and unintentional discrimination, not only in Keyes, but in the whole line of cases going back to Washington versus Davis.
Could I go back to Judge Edwards' question? I'm sorry. About the extent to which the analysis here fits into Justice Kennedy's concurrence in parents involved. Yes. Would your response to the question that Justice Kennedy proffered, for instance, the drawing of attendance zones, is the only thing that prevents, in your view, the attendance zones that we're looking at on the record before us from the attendance zones that Justice Kennedy posited in his concurrence, the fact that you don't understand there to have been a consideration of less intrusive alternatives? And isn't that something that's fairly easily remediable?
Yes, Justice Duncan, the difference is there was not the consideration of race-neutral alternatives. Whether or not it's easily remediable, I don't know, Your Honor. The record doesn't tell us. What's key is, in parents involved, Chief Justice Roberts wrote an opinion for 4 justices rejecting that diversity was a compelling interest with regard to elementary and secondary schools. However, Chief Justice Roberts wrote an opinion for a majority. Justice Kennedy joined this, saying that race could be used as a factor in assigning students only if there was a showing that no race-neutral alternative could work. There is no demonstration in the record of this case that a race-neutral alternative could succeed.
What do you mean? Give me an example of a race-neutral alternative in a society with such impacted class and caste demographics. How can there be a race-neutral criteria? It can't be high school average, I would submit, because of the studies that show a correlation. It can't be family income because of the correlation. If you pick any criteria, be it residential neighborhood, family income, you're going to be using a proxy for race. How can there be a race-neutral criteria? And help me find an example of one.
Your Honor, it may be possible in some school districts to simply redraw attendance zones to achieve desegregation. And so, for example, rather than cutting a city horizontally, maybe if you cut it vertically, you'll be able to achieve desegregation. There's nothing in the record of this case to indicate that that would be sufficient, certainly without the tremendous busing that's involved here.
What would drive the zones, the lines that were drawn, what would drive those lines? Wouldn't they have to be driven with an eye toward the racial demographics of where that line was going?
But I think what Justice Kennedy was... Right. Well, but I think what Justice Kennedy was saying in Parents Involved is there's a difference between drawing attendance zones with an eye towards race and assigning individual students to schools with an eye towards race.
But the question is, what factors are you considering when determining how to draw those attendance zones? What are the factors that determine how you draw them?
Undoubtedly, many factors are used in drawing attendance zones,
One
including,
of which is race.
Well, and Justice Kennedy doesn't preclude the use of race in drawing attendance zones. The language from that Justice Edwards quoted indicated that. However, I think it's also important to indicate that there are other factors that are used in drawing attendance zones, including convenience of the students. I don't want to lose sight here what I said to Justice Duncan, that in Swan, this court specifically said, if there's going to be busing as a remedy for desegregation, it has to be busing that doesn't hinder the education of students. This record shows that both of the plaintiffs' education was hindered by the extensive busing.
Let me ask about that, because why shouldn't we abrogate our decision in California versus Johnson and apply a different level of scrutiny? Why shouldn't we say that since the governmental practice here impacts both blacks and whites exactly the same, both groups suffer the same level of adversity, the impact is not based upon any pernicious motive. It's not driven by animosity or racism. Why shouldn't we simply say, where that is the case, the standard to be applied is not strict scrutiny, but either rational basis or maybe heightened scrutiny?
Your Honor, this court has repeatedly said that any use of a racial classification warrants strict scrutiny because any use of a racial classification conveys messages within society that are pernicious. California versus Johnson that you mentioned is exactly on point. That's where the California prison system used race in assigning prisoners, presumptively segregating prisoners when they were first brought into the system. And Justice O'Connor's opinion for the court there expressly said strict scrutiny is to be used. If nothing else, as Justice O'Connor says in her decision in Croson, it's to smoke out the impermissible motives.
But I'm convinced by your argument, given the difficulty of trying to find a race-neutral alternative, that maybe what we said in Johnson and those lines of cases was wrong. Maybe we shouldn't use heightened scrutiny here.
Your Honor, I think the problem is, as I was saying, that demographic realities, as well as decisions from this court, are going to prevent effective desegregation, racial integration in almost every American city. That's why this court should turn to equalizing educational opportunity.
Mr. Chairman, Chemerinsky, let me focus you on the concept of equality, which is what you seek. As I understand it, some significant amount of the inequality intra-district stems from an inequality in private sources of funding, private donations from parents, and the like. Is that correct?
Yes, Your Honor.
What are we to do with that? How are we going to ensure that there's an equality of the sort that you seek with that inequality in private sources?
What does a remedial, in other words, what does the remedial order you would have us issue look like?
This court should issue an order that says the funding in each of the high schools in the district, that's what's before us, should be equal. If that then means that some schools are getting more money from private sources, then the school district would have to equalize that in the other schools through tax systems.
So that's a pretty radical, I'm just saying that my question specifically is that's what I think everyone wants you to focus on. Because you're correct that the record says in assigning they use race explicitly. So I can see what you're asking for in the first part. You're saying, say that this use of explicit race violates parents involved. Now, that may not get you too far, as people point out, because they'll get the same result, if not through a lottery, by drawing district boundaries. But the second part becomes important. And the second part, you are saying, not even what New Hampshire said. I mean, you're saying that the Constitution of the United States, looking at the authority to the contrary, provides a right in the Constitution to an equal expenditure for every child. Now, this has nothing to do with race anymore, or it may be, but that happens to be a fact, but nonetheless. Whether it's a poor child, rich child, poor parts, or is it just intra-district, and what happens if the parents want to spend more in a math class? Or what happens if one is a technical high school or a scientific high school? And what happens if, and we can imagine, how are district judges supposed to implement the rule that you will tell me, and we're in the process of replying, that you're advocating as a matter of constitutional law?
Your Honor, many states following this court's decision in San Antonio Board of Education versus Rodriguez, as a matter of state constitutional law, ordered equalization of expenditures among schools. Since this has been done under state constitutions in some states, there is precedent that federal courts can look to. And what I'm saying is that Rodriguez said that inter-district disparities in funding do not violate the Constitution. But nothing in Rodriguez denies that intra-district disparities violate the Constitution.
But as many, if not more, state courts said that that is a matter left best to legislative and educational policymakers and not the courts. And I'm trying to get a handle on what that would look like, and I'm still not sure how you'd implement it.
I think, Your Honor, it's implemented by an order from this court that the schools should have the same per pupil expenditures, at least absent some compelling justification for deviation.
That won't equalize. The minority district here is so far below the white district, you would end up with what I assume you would argue is unequal expenditure in favor of the minority students in order to get them equal.
Your Honor, at the very least, we should bring the minority students up to the level of the white students.
Well, just to follow up on that, we have a school district that is very well-meaning, and it discovers that there are more minority single parents or leave nobody home at 3 o'clock. And so what they say is when families are not home at 3 o'clock because both parents are working, we have special reading programs, game programs, or whatever they have. In other words, they make special efforts, which happen to be concentrated on the poorer sections of the community because that's how it works out. And you're saying, that's forbidden?
Your Honor, I would be delighted to defend such a system.
No, I would too, fine.
But, Your Honor,
what's your
we are
rule?
so
What we
far
want to
from
know is
that.
what is the rule?
We are so far from that in the Harris-Wald School District and in most school districts in the United States, because exactly the reasons that Justice Duncan points out, we're in a situation where the poorer areas have less in the way of parental contributions, less resources than the more wealthy schools in the same district.
What is the constitutional source for that kind of a remedy to equalize that situation?
The Equal Protection Clause of the 14th Amendment, Your Honor.
Can we do what you request, counsel, without making education a fundamental right?
Yes, Your Honor, I believe that you can. Because I believe, going back to the language from Plyler versus Doe, this court has at least recognized the fundamental nature of education. And I think you can say there is no rational basis, let alone no important or compelling interest, for the kind of disparity in school funding that exists within school districts today.
But there is also language in Milliken versus Bradley that says there is no more fundamentally local interest than the operation of school system.
Exactly, Your Honor. Milliken versus Bradley said there cannot be inter-district remedies to school segregation without an inter-district violation. We are not here dealing with the Milliken-Rodriguez situation of across district lines. We're here dealing with tremendous disparities within a district, and not disparities that are favoring the poorest students, not giving them more compensatory education, disparities that are very much favoring the wealthier students.
Let me go back to your assertion that Justice Kennedy bought into some of what the plurality was saying because he joined the judgment in part. It almost looks like tongue-in-cheek because Justice Kennedy says, look, diversity is a compelling educational goal. Racial composition can be considered by the school district. Racial isolation is a factor to consider to determine whether or not a child is being denied a fair educational opportunity. Now, you see, you point to the two kids who are before us claiming our educational opportunity is impaired because you have to ride 90 minutes. The school district said there are many more kids who are in the segregated schools whose educational opportunity is being impaired. And so we want to mix them.
My time
You
is
have,
up.
your red light is on, counsel.
May I answer
so-
briefly so I
yes.
save the rest of my time for rebuttal? Chief Justice Roberts wrote an opinion that was in part for a plurality, but in part for majority. Justice Kennedy concurred in the judgment. In the part where he was concurring, he said, race can be used as a factor in assigning students only if there's no showing of a race-neutral alternative. There's no such showing in this case.
Okay. It's ruthless.
Thank you. Did you want it? I don't have a cold or anything like that. You take it.
I begin with a disclaimer. It's not easy for me to say, may it please the court, and not answer at the same time. So if I find myself asking a question or making a point and answering it, you'll have to forgive me. I'm not used to this. Likewise, when I looked at the district court record, which was so ambiguous, I decided to write my own district court decision. So, with those disclaimers, with respect to the challenge to the use of race in the Harris-Wald Township, I read Justice Kennedy's concurrence, and I read the case law supporting this very differently than my opponent. At the very least, and it doesn't say a great deal, the courts have suggested that diversity. There are two components of Brown versus Board of Education. One is the component that we all know about, which was the admonition to stop state-sponsored segregation of schools. But the second component, which is written in much more broad terms, which is education is the foundation of good citizenship. Brown was about citizenship. It is a principal instrument in awakening the child to cultural values, in preparing him for
Ms. Gertner, is there a
Excuse me?
That was in the context of state action, of state laws.
No, I understand.
Requiring segregation.
And that has been, to some degree, transmogrified in Justice Kennedy's concurrence and in the language of Justice Breyer as well, to suggest that diversity, strength comes from people of different races, creeds, and cultures.
Your adversary, Ms. Gertner,
Did you call me Judge Gertner? No.
I can call you Judge Gertner if you want.
Does your wife
answer to anything at this point.
Your adversary made some hay of the fact that on this record at least, there is no evidence that the school district undertook some race-neutral analysis or alternative. Is that correct? And if so, what should we make of that?
Well, that's an interesting question. If the goal here is not racial balancing for its own sake, but to create an environment that is a diverse environment, if it's about citizenship, if it's about learning how to
Well, what about a lottery? That was alluded to as well. That's a obviously race-neutral alternative, is it not?
That would be a race-neutral alternative. It's not, but it would be episodic. It's not clear that it would be, that it would achieve the goal here. In other words, if the ultimate goal...
What is the goal, I think, is one question. And if you're not starting from an identified point of a disparity, how can we know, or how can you know, more importantly, when you've achieved what it is you seek to achieve?
Well,
what is it you seek to achieve?
Are you saying segregated schools are inherently unequal, or integrated schools are inherently good? What is your starting premise?
Well, I'm taking a point that a school can decide, as a fabulous district court judge did in the Lynn School case. A school can decide that education is more than just numbers and test scores, that education in a multiracial, globalized world means that you have to participate in a class with someone of a different race or culture or ethnic group or economic background next to you. Let me give you an analogy, which again, I don't know whether or not...
I think already Grutter gives you that. You're talking about the importance of diversity. But what do we do here with the adverse impact of this plan on these two students, on McNeil and on Oglethorpe?
Well, the question is where the burden lies. In other words, on the one hand, the question is whether or not the people challenging this need to suggest that that burden is widespread. Obviously, it's not widespread.
But should we then ignore the hardship that's befallen two students just because of the fact that one is black and one is white, and just say, you're not there yet. You've got to get to the term critical mass. That brilliant judge who wrote Lynn talked in terms of critical mass. Do we have to wait until there's a critical mass of misery before a court can become concerned?
But again, let me roll this back a bit. If one believes, particularly through K through 12 education, as opposed to elite schools and law schools and medical schools, that the school board can say there's a value to citizenship here, there's a value to multiracial citizenship, that's an independent value to some degree, then the least drastic means is achieving a multiracial
Well, all right, I'm counsel. Some of us have the tendency to think that our dissents are the law.
Oh, if it were only true.
The fact is, even dissents that refer to Lynn in other cases are dissents. That means they're not the law. So if, in fact, we look at parents involved, 4 justices say never explicit race, and Justice Kennedy says a system that, what he calls, according to a crude system of individual racial classifications, is a different matter, and he joined that third part. And when you look at the examples that he gives, not one of them uses race, except that they use things that are correlated with race. But they don't mention race. Now, a dissent wisely pointed out that that was not a sensible distinction. That dissent was a dissent. And so what seems to be is that you can, in fact, divide neighborhoods, draw attendance zones, use strategic site selection, and allocate resources, target this, that, or the other thing, but not use race explicitly. Now, I don't know how you read those 3 paragraphs there without coming to that conclusion that that is the law. So therefore, I look at this, and it says that it uses race explicitly, and that seems to be what 5 members of the Supreme Court have said you cannot do. Now, what do we do about that?
Well, the question is whether or not Justice Kennedy's concurrence dare I say, is less than clear in this regard.
Where is it less than clear?
Well, he says in
It
general
lists 10 things that are correlates for, but not explicitly mentioned race, and then it condemns, in the last sentence, the explicit use of race.
One way of interpreting the paragraph that says, with general recognition of the demographics of neighborhoods, allocating resources for special programs, recruiting students and faculty in a targeted fashion, tracking enrollments, performance, and other statistics by race. So what my understanding is that he was suggesting, as to some degree the Grutter decision suggests, a multifactorial approach in which race is not dispositive, but one of many factors. And arguably, that is what's going on here, which is
But
to
if there's
say...
a correlation of, let's say, 0.8 amongst all of those factors, how can you say that race is not the positive? We just use different proxies for race and say, well, we're not looking at race, we're looking at income. We're not looking at race, we're looking at where the person lives. We're not looking at race, we're looking at the quality of the educational opportunities where the person is. All of those things are proxies for race.
Proxies for race is a different way of saying correlate with race.
Correct.
They plainly correlate with race. Whether they're proxies for race is a different matter. One can say that it's important to have a diverse environment, that is in terms of income, educational background, et cetera, and race being part of that. And even if the other factors are correlates of race, your purpose here is to create an urban, multiracial school. This is actually more complicated. There are 4 zones. Zone 1 is mostly white residents. Zone 4 is mostly black and low income. Zone 1 is high income. And then the 2 and 3 are mixed. This is every student, 50% of students from each zone goes to one school and 50% from the other. In order to determine who's going where, you consider race, family income, standardized test scores, parents' educational level, and sibling preference.
Now, are you
The
trying to
question is whether, excuse me.
Are you trying to tie this to Justice Kennedy's language toward the end? It is true. It's a little bit confusing. What the Chief Justice referred to is in the beginning, but at the end, he says, a compelling interest exists in avoiding racial isolation, an interest that a school district, in its discretion and expertise, may choose to pursue. Likewise, a district may consider a compelling interest to achieve a diverse student population. Race may be one component in that diversity, but other demographic factors, interests may be considered too. Is that what you're resting
That is
on?
exactly what I was thinking.
Why didn't you say that?
Well, I was going to get to that. I have an analogy, sort of a metaphor, which, not an analogy, a metaphor, which I wonder would make sense here. Let's assume there was a one-room school, one building was the school, public school, and there were 2 rooms in it, room 101 and room 202. And everyone in the area came to this one school. And all the black kids went to 101 because they self-segregated, and all the white kids went to 202. Could the principal of that school say, mix it up, guys? 50% of you go to 101, 50% of you go to 202, because I don't want to preside over a school system in which the people sitting next to you are the people that look like you. I want it to
No,
be
you would
mixed.
try alphabetical first, probably.
Alphabetical would be, well, except that if the, again.
That's what alternatives are, counsel. The problem
And
is,
counsel,
in this country, we don't have a good history of letting legislatures put race-specific classifications in play. And the question is that parents involved clearly said, when you're doing so and denying a benefit based on that classification of race, that's not allowed. Now, we can find metrics and correlation that deal with race, but that clearly seems to be flies in the face of what you're doing in your school district.
Legislature is one thing. One of the other things that is a history that is implicit in our history since Brown versus Board of Education is the deference, once they're acting in good faith, given to school boards to make decisions. And this is children within a public school, within an urban environment, have to be sorted somehow. And the question is, what's the sorting mechanism, and whether or not that's a multivariate, multi-determined concept rather than race alone, and whether those factors key in to an educational purpose.
At what point will you have achieved the level of diversity that makes for that perfect blend of mix that creates the good citizen?
Well, you know, in that regard,
Doesn't it have to keep getting tweaked?
Yes.
The more successful you are, the less you need it. So it's an ongoing, it's never quite there, is it?
Well, again, if success is defined in perfect integration, if the issue was integration, and that would be one thing. But what I'm suggesting is key to these decisions, to Bruder, to parents involved, is the notion that we can try to set up a classroom that maximizes educational opportunity for all children. And part of that is learning. I remember when I had my kids going to school, you know, the first few grades were works and plays.
But what I'm still grappling with is how, I think you've told me who defines it. I'm still having trouble understanding how it's defined.
Well, the only way that it can be defined is what comprises educational opportunity, the record in this case. There are better records, and if I had written the decision, it would have been better. There's no question about it.
No doubt.
But the question is, it may well be that in these days, every part of compelling state interest has to be litigated. So in other words, the question of the relationship between the demography of a classroom and its relationship to educational opportunity needs to be litigated. That was litigated in the Lynn case. What is the relationship? Does it matter? Well, yes, there's studies that suggest it makes an enormous difference if you're the only black kid in the class. It makes an enormous difference if the class is overwhelmingly minority, not necessarily in the way Brown versus Board of Education talked about it, which is feeling inferior. Okay. But
I believe my colleague, Justice Donald, has a question.
Well, yes. Thank you very much. Since you mentioned Brown, I wanted to ask you, does the principle in Brown simply abhor the mere existence of segregation in schools, irrespective of whether a state is responsible for it or not? And depending on your answer, I would ask, in this case, is there anything wrong with using simply a socioeconomic metric for, as the basis for school assignment?
Well, it's not clear that there would be nothing wrong in that. The question is whether this plan offends the Constitution. The fact that now the question is whether or not the existence of some alternatives suggests that this is not the least drastic means.
But that is the question, isn't it? If you can possibly achieve, by use of the criterion that Justice Donald referred to, then it seems to suggest that there is a less intrusive, a less clearly race-conscious or race-defined mechanism. Therefore, your proposal can't be constitutional because it has ignored that option.
There are two answers to that question. One is it may be that, for example, an income-based approach would have the same disability that we talked about here, which is there may well be kids who will be bused more than 90 minutes. In other words,
But not based on race.
But not based on race. And so the question is whether or not that will achieve the same kind of educational opportunity that this school board determined was essential in this case. And that's ultimately what it comes down to. Income is part of the consideration here. Standardized test scores, family income are part of the picture here. And at the end of the day, in effect, race is part of this.
Counsel, let's...
Does the dialogue that's been going on for the last half an hour or so illustrate that perhaps we've all fallen into a trap? And the trap is that we as an institution are competent to make intelligent, efficacious educational policy when we really are not. And you have a situation where, for example, across the campus, you have an education school that has been looking and wrestling with these issues. How do you achieve equality of outcomes? What's the best way of funding deficits and so forth? They've been studying this for 50, 75 years and haven't come close to solving the problem. Why do you think, do you think the trap is that we are wrestling with a set of issues that we simply have no at the end of the day, no real institutional competence for?
I think that the concept, for example, of a compelling state interest married to the concept of deference to school boards is an uncomfortable mix. On the one hand, compelling state interest invites courts to balance and weigh and
it's not just
understand.
uncomfortable, it doesn't seem to work.
Well, the question is, what's the constitutional floor? There may be better alternatives just now to achieve better education, but this is the question is whether this approach is constitutional. All that I'm suggesting is that one way of looking at Lynn, one of the cases that's cited here, one way of looking at Grutter, is the goal is defined in terms of the remedy in effect. The goal is a multiracial environment, and that's a goal that makes difference.
Let's return to the basic premise of diversity, which is something we've thrown around here in a generic fashion as to what is diversity. And I take it your premise is that facial diversity alone achieves viewpoint diversity. Is that correct?
No, I'm actually not talking about viewpoint diversity.
What then is your goal if the compelling interest insofar as education, if you're not there to achieve the viewpoint type of diversity, does facial diversity alone achieve it?
Well, again, studies suggest, and the studies in Lynn suggested, that there were students who came out of this environment who say, you know, it's now more natural for me to have a black colleague than I ever had before.
How many black colleagues does that person have to generate that feeling? And how do you measure it?
Right. And if you ask me to get into critical mass, I won't. But the answer is that there has to be some mix, and that taking race into account, along with factors A through D, is not illegitimate. And it's not illegitimate because the ultimate goal is a multiracial, learning how to grow up in a multiracial environment.
Given the globalization, at least in terms of the prospect of learning in different circles and individuals associating to a greater degree, is it not possible to achieve viewpoint diversity without actually having facial diversity?
Viewpoint diversity doesn't resonate as much in K through 12 as it does in a university or a law school environment. In K through 12, it may well be the symbolism of going out to play with someone who is simply different. In other words, I'm not sure that the two concepts are equivalent. Viewpoint diversity on the one hand, and simply learning how to grow up in a multiracial world.
Ms. Gertner, can I press the constitutional floor a little bit? In this record, as I understand it, there are also ability groupings within a school. So in addition to intra-school district issues, there is segregation within schools based on placement of students in advanced classes rather than other classes. Is it the school district's position that it can also use race in connection with determining who gets into an advanced class by way of an ability grouping?
That's not in the record. So far, the record that we're dealing with is just a sorting record. Who
Is
goes
there
to what
anything?
school?
Is there anything, if we adopt your position, that would prevent the school district from doing that?
When it comes to merit-based decisions, that's where I distinguish between elementary schools and law schools and medical schools. When it comes to merit-based decisions, it seems to me the equation is different. We're now just talking about who's going to be next door.
What if all of the white students in a school were in advanced courses and really didn't mix at all with the black or other racial minority students? Would the school district then be entitled, given your position, to use race as a factor in placing some of the minority students in the advanced courses, notwithstanding merit issues?
I would have trouble with that. I certainly think that that
Why?
would be, because that's a different issue than sorting, as I said, than who should be sitting next to one another. That's an issue that it may be, for example, it's much like the employment discrimination cases that deal with testing. Then it may be, sure, let's look again at what our criteria is.
But given the correlation, use your word, not proxy, between income and achievement, and the studies have shown that that, in fact, is what tends to happen, that once you get a building that is diverse in whole, within that building, certain things start to happen. Black students tend to get assigned at a higher ratio to through tracking processes to non-advancement kinds of courses. If your premise is correct, what would prevent the school district from doing that? In fact, wouldn't they have to do that to make sure that the educational opportunity in terms of the multicultural experience in the advanced courses was as rich as you're saying it needs to be? Wouldn't they have to step in and make sure that the school had not created little enclaves within itself so that you have a, if you look at just who's assigned to that school, it's pretty diverse, but within that school, it's totally not diverse. And we could end up with a situation where your plan achieves absolutely nothing except students traveling 90 miles to get to
be
a
at the
building in
bottom.
which they're segregated.
I can see a continuum, which our cases describe. And the continuum could be, is there anything wrong with providing the black students who are likely to be at the bottom of the class with additional help? No. Anything wrong tutoring them? Anything wrong looking at the standards by which we define who got into that class? No. Quotas, mixing that explicitly at that level, probably yes. But that's not what we're talking about here. We're talking about an assignment zone, an attendance zone, which is who's going to be sitting next to one another.
I want to be sure you have some time to deal with the other part of this
Yes.
argument. So,
Yes.
counsel, let me ask you, assuming that we read that you cannot do this because it's explicit use of race, then what do you think of the possibility of, let me put it in the most least threatening way, suppose the court were to hold, so I don't know why the school is spending such diverse amounts of money and so spending so little on the poor neighborhoods and so much on the wealthy neighborhoods. This is a single school district. What do you think of the proposition that where poverty in a particular region of the city, of a single school district, is highly correlated with race, then under those circumstances, we will presume that a significantly unequal expenditure, a gross disparity of expenditure, unexplained by clear educational reasons, does amount to race-based discrimination. And therefore, the Constitution forbids it. You have to have, in such an instance, within a single school district, more equal expenditure among the poorer and the wealthier areas of the city, at least, reserving all else to a future case, at least where that poverty is highly correlated with race.
That would be engrafting, essentially, a disparate impact model on this record. In other words, you're saying the net effect of property tax-based
It's a single
division.
school district, after
Right.
all. The
But
money comes from a single group of people. It goes into a single pot. And I don't know why they're spending this money so disparately.
But the net effect, but you're saying that they have decided, and we believe in local control, particularly financial issues, they have decided that property taxes in a particular area will fund the schools. And you're saying the net effect, one would have to say that the net effect of that decision is to discriminate on the basis of race. The problem with that approach, looking at it that way, would collide with Washington v. Davis, would collide with a model that rejects a disparate impact in a 14th Amendment context.
But there are studies that indicate that the intra-district disparities often come because the best, more experienced teachers go to the non-minority schools, the schools that need them most. And so they're being paid more, so the per pupil expenditure is higher. Could a court say, the one thing we can surely do is to say, get some of those good teachers in the schools that need it? Can we do that?
I don't think that you can do that. I think that the concern of Rodriguez with respect to sort of the incoherence of poverty as a basis for an equal protection challenge maintains. How far do you go? What comprises equalization? And I think it was your point, Judge Edwards, that in a situation where there are gross disparities, equalization may not be remotely sufficient. In other words, that it may be that you have to spend more in order to equalize. The court, speaking of competence, very much in the Rodriguez line of cases, found itself unable to determine what equality of expenditure.
So why don't you give us a prescription? If we disagree with you about parents involved, some of us may, some of us may not, what's the prescription with respect to the equalization solution that your adversary has foisted upon us?
I don't see how Rodriguez can be upended without a conclusion, on the one hand, of a finding that poverty is a fundamental right, a right not to be poor is somehow a fundamental right, or that education is a fundamental right, triggering strict scrutiny.
Go with the lottery and assume that the money will follow the white students when they're bused, right?
The lottery is a random, is the notion of telling.
But given this weird district, it's likely you're going to get a diverse two high schools, and there are some of us who think that if you put enough white students in the bad school will no longer be bad.
Well, in this situation, though, presumably the schools are relatively evenly divided, black and white. We don't actually have demographic figures. In Lynn, as I think I described before, in fact, because the percentage of minority was not more than 50%, you really could have a balanced school system, and that was not necessarily the case. We don't have enough in the record with respect to that. But I think the question is, if a school system decides for educational reasons, not for race, not for...
Wait. You said for educational reasons, not for race, but you spent a lot of your time arguing that one of the important educational things is cross-contact, multi-cultural contact. So how can you separate those two things, not for race and not for educational?
There have to be findings with respect to the impact, this as an educational goal. It can't be assumed. We assumed it in Brown versus Board of Education when the court talked about the importance of citizenship and learning how to be good citizens. We assumed it. I think that today we have to test it to some degree. What's the relationship between learning in those environments and learning in segregated environments? What's the relationship between learning in a diverse setting and not? I think it has to be tested and not necessarily assumed.
Well, you assumed that when you put the plan in place, though.
But, excuse me?
Didn't you assume that when you put this plan in place? Wasn't that one of the driving things behind this plan?
I'm assuming that there were findings that were so elaborate that they comprised 84 pages. That Gary Orfield testified below, just as he did done in the Lynn case, because actually one of the things that was clear in the Lynn case, and I think it's an important point to make, is that the things that we assumed can't be accepted anymore, and they do have to be proved.
Would the funding issue be more manageable and less problematic constitutionally if the goal were to bring everyone to the same level of being provided a sound basic education as some state constitutions do, as opposed to always equalizing, continually equalizing upward to meet the push of private resources?
We have problems under the constitutional framework of the federal constitution, which is an equal protection analysis. The states that have done that have had in their constitutions a provision for about adequate education. And they have sought to implement what comprises an adequate education. And that has not been an easy path. But certainly an equal protection model is in effect too gross a model, too gross a measure to be able to deal with these kinds of issues. And I think that that's what the Supreme Court has said.
Counsel, I don't understand. You come to this court, you know that there's incredible disparity in funding already in an intra-school district, and yet you want to use a race classification to deal with what I'll call soft issues of isolation, getting on kumbaya type issues. But yet you know that the pressing problem in education in this country are low test scores, retention problems. Aren't you you're arranging deck chairs on the Titanic, aren't you? Shouldn't you be using your money to have better schools and address low scores? The French call it triage. How do you
call it separate but equal?
Yeah.
That there are better ways of doing this. There may well be better ways.
No, using race classification is not a better way based on parents involved. We know that.
Well, the question is race among, it is not entirely clear to me from Justice Kennedy's concurrence, this gets back to what we were saying before, that a multi-factor test, particularly in K through 12, where the goals are different than in a medical school or a law school, et cetera, would not be appropriate. Whether that's all to make our schools better is a separate issue completely. Whether this is sufficient constitutionally, it seems to me, is the matter in front of you, and whether a school board should be deferred to under the circumstances and how to sort
What's
the black
before
and
us, it
white
seemed
kids.
like you're involved in racial balancing.
That's
And
not
that's-
what they say they're doing.
But on this
and
record, that seems to be the main thing you're doing is racial balancing, because you haven't made a case for doing anything else other than impacting adversely to students, and otherwise continuing a disparate funding system.
All right, and we have to be brief, counsel, because the red light is on, so
Okay.
could you answer briefly?
The program in this case was not race balancing. 50% of students from each zone went to one, 50% went to the other. As part of the decision of which individual would go where was a number of issues, including sibling preference, parents' education level, standardized test scores, family income, and race. So the enterprise here was to create two diverse schools by all measures, family income, educational background of the parents, as well as race. They made a finding that that was consistent with their educational mission, and that's the finding that I would ask you to uphold. Thank you.
Thank you very much. 5 minutes reserved.
I have two arguments.
Could maybe three, perhaps, because one of the things I'd like for you to address, your focus on having us order equalization of spending. How is that consistent with our Jenkins ruling, where we held that we could not order states to fund magnet schools? If the remedy you're asking us for, how can we do that without overturning Jenkins?
Quite the contrary, Your Honor. In Missouri versus Jenkins, this court specifically held that could order a school district to increase taxes to pay for schools. In the Yonkers case, this court made clear that it is permissible for a court to order a tax increase if it's necessary for a civil rights violation. We are not asking here for a tax increase. We are simply asking for a simple judicial order. And I'll here quote the words of Chief Justice Breyer. At the very least, there should be an equalization of the funding of the schools in this district. And that's the second argument that I was making. The first is that the desegregation plan of this school district violates equal protection under both this court's decision in Swan and under parents involved. In Swan, this court said there can be busing, but only for reasonable distances that don't hinder education. This record shows that the 90 minutes for each of the plaintiffs hinders their education. Judge Gertner's only response is, but it's only...
The assumption of the school district is that all of the rest of the minority students in the poor district are suffering from hindered education because they're in a de facto segregated setting. So, I mean, I'm listening to you talking about two who have a hindered education. The school district is saying, in our expertise, there are 200, 500 minority students in a bad school, in a segregated school, and the reason they're suffering is because it's de facto segregated school.
Your Honor, the record doesn't support that assumption. The record in this case doesn't show, as Judge Gertner assumed, that it's only two students who are being bused 90 minutes each way, and all of the rest are in their neighborhood schools. There are two plaintiffs in this case, and certainly for these two plaintiffs, the busing is unconstitutional under Swan. If nothing else, we need to have a different record to indicate what you suggest, that the rest of the students aren't bused.
But I take it you think it would be constitutional simply to have within each of these four neighborhoods 50% drawn by law.
Yes, Your Honor, there's nothing that prevents lottery.
Now, I did emphasize those parts of Justice Kennedy's opinion that suggest you can do that, but you can't just use race at all, period. Now, Judge Edwards did point to another part of the opinion, which seems to suggest maybe sometimes you can.
Which we saw you looking for
yes.
while you were waiting.
So what do you have to say about that?
Your Honor, I think what Justice Kennedy does is draw a distinction between using race as a factor in assigning particular students to schools versus using race in doing things like drawing attendance districts. He sees that as a distinction, and it is what 5 justices say. Race can be used as a factor only if there's a showing that no race-neutral alternative could work. If you look at page 8 of the record that's before you, it says that both as to Oglethorpe and McNeil, the following factors were used in assigning them to schools. And the first factor is race. Under this court's decision in Parents Involved, and I agree over a brilliant dissent that you wrote, it is still
not quite brilliant enough.
It is still permissible only if you've shown there's no race-neutral alternative. And Judge Gertner points to the brilliant opinion in the Lynn case, but what she omits is that was a decision in 2003, 4 years before this court's decision in Parents Involved. That decision, I don't think, could survive what this court said in Parents Involved. 58 years after Plessy versus Ferguson, this court finally in Brown versus Board of Education held that separate can never be equal. We are now 58 years after Brown versus Board of Education. It's time for this court to recognize that demographics and this court's decisions make racial integration impossible in most cities. But equal educational opportunity is possible. It is a constitutional mandate, and the court should order it in this case. Thank you.
Thank you very much. Thank you, both counsels. Very good, and thank you.
You're terrific.
Departing from the realism of the Supreme Court, what we're going to do in the next few minutes is each judge will have an opportunity to say what he or she is actually thinking on any subject at all, or not to say what they're thinking. I've learned long ago that you cannot control what a judge will say. And so we'll begin, I think, in reverse order of seniority. We're going to begin with Judge Donald, and then we'll go back and forth until we get up here.
Thank you, Justice Breyer. And let me thank the audience for being here this afternoon, and thank the advocates for your argument. It was really quite superb. You know, I think the argument, the presentation of this case really, I think, tees up squarely the important but difficult issues of trying to make certain that all students have an opportunity to get a quality education, and also realizing that resegregation is a real and growing problem, and that it threatens the ability for students to get that fundamental education. In the Cooper v. Aaron case, the court stated that state support of segregated schools through any arrangement, management, funds, or property cannot be squared with the amendment's command that no state shall deny to any person within its jurisdiction the equal protection of the laws. So do we understand that to mean that the school district's attendance zone set up in a way where the majority of white students go to the affluent high schools and the majority of minority students go to underachieving or more poorly funded schools? And I think, as one of the justices on the panel says, that where you have the affluent students attending, that is generally going to be where the money is going to go. And I think that, as the judge said in the Lynn case, you know, there's some overarching, compelling interests that relate to this issue that the courts have to look at. And one is promoting racial and ethnic diversity. There's a real value to that. And I'm not speaking as a judge, and I'm speaking as a panelist. Increasing educational opportunities for all students and improving the quality of education. And one that did not manifest itself in this fact pattern, but was certainly present in Lynn, and I think is ensuring safety. Because we don't sit here in some ideal situation. We know that where poor children are going to school in an area that is, where there's tremendous violence, where children are hungry, where there's a good deal of external threats that interfere or distract from their concentration on education, that is going to impact that student's ability to get a real education. The motivation to curb that violence or to enhance otherwise conditions is going to be, I think, diminished where the students there have no economic voice, where they have no economic power. That's the reality. And the court has to look at the other issue, and that is, what is the jurisdiction of the court to address a particular issue? There are some wrongs that are simply not within the court's purview to right. But where the court can right a particular wrong, then the court is obliged, I think, to do that. And you heard those questions coming up today. I think it's important for all of us to realize that minority and poor students cannot just be self-advocates. Those who have, in their view, no stake in the game, those who have resources, have to also become advocates for this whole notion of equality of opportunity and for education, because society as a whole benefits that. And while our laws are tremendous, we have to recognize that laws are not self-executing. They depend on the hands, the hearts, the minds of people of goodwill to make that law a reality. Were it not the case, now look at my own situation. We know that Brown was handed down in 1954. The first of the Brown cases was filed in district court in 1951. It was filed a few months before I was born. When the Brown case was handed down, and I'll ask you all not to do the math, I was 3 years old. And yet when I started first grade in Olive Branch, Mississippi, notwithstanding the majesty and the importance of that case, I started to school in a 2-room cinder block school with no indoor facilities, with no running water, with the first and second grades being in one room and the third grade being in another, with schools for black kids only going to the 8th grade and those kids going to the church up the hill. Notwithstanding the law of the land being that separate but equal is inherently unequal, until you have enforcement, until you have application, the law is just the law. And we have to recognize that. But those things that the law can address, the law must address. Thank you.
Thank you very much. Judge Graves.
In my opinion, the school district has the better argument in this case. I think in parents involved, Justice Kennedy propped open the door for some race-conscious school assignment plans to pass constitutional muster. I think that door should remain open. I think this plan is one which includes race as one factor among multiple other demographic factors that are to be considered. It also includes family income, parental educational level. I think it's the kind of plan that passes constitutional muster. And I think given that this court has allowed race, has allowed at least colleges to consider diversity in their admission criteria, it just stands to reason that it makes sense that when you're considering diversity and the opportunity to interact with people from different cultures, different backgrounds, that same reasoning and logic would extend to a time in a child's life when they're adolescent, very impressionable. And so I think to the extent that Grutter recognizes that, I think this plan along those same lines is one which passes constitutional muster. I think the parents' argument regarding the equalization of resources is very attractive. I would love to write an order that said every school district has to spend exactly the same amount of money on every child. But the federal courts have been very reluctant to get involved in an area where it's typically been considered a matter for states to deal with, for local governments to deal with, and given the precedent, I think the precedent counsels against us, in this case, looking to implement some plan for equalization of funding. And so I think my inclination would be, while as I typically say at a post-argument conference, I remain open and defer to the wisdom of my wiser colleagues. And so I haven't heard from them yet, and I'm open on this, but my vote would be, I think, to affirm the district, the appellate court, the lower court.
Thank you. Judge Loyer.
I'm going to give neither wisdom nor a vote.
In that order.
But, because I don't have to. But we're in a little bit of a pickle. It seems to me that parents involved, and you heard some of the back and forth about what it says, and more particularly what Justice Kennedy says, and there's some ambiguity, but if you agree that parents involved and that Justice Kennedy's concurrence more or less says that race cannot be used as a factor in the context at least of K through 12 education, then it's a pickle about what schools can do. Now, Professor Shereminsky, at least the guy at the podium, was arguing, and it's not an unwise argument, and it may be the argument that needs to be made from now on, that the school district should have, in the first instance, explored race-neutral alternatives. And what that suggests to me, that there's a little bit of a silver lining in that thinking, what that suggests to me is that school districts that go through the actual process in a substantive way of exploring race-neutral alternatives and still find themselves with a deeply segregated school district may be then able to use or employ race as a factor. So that's an opening that parents involved left for us to consider. The other thing that I think is very interesting, of course, is that Chief Justice Roberts, I think, made it very clear that he was, at least in the context of parents involved, not talking about higher education, but merely talking about, and so Grutter still applies, but merely talking about K through 12 education. Of course, therefore, that means that higher education and using race as a factor in higher education is not legally implicated by parents involved, but I always worry about pipelines, and anyone who's ever heard me talk about that knows how concerned I am about that. And the only way you get a diverse group of people, however you measure diversity in higher education, is by having people who are well educated and can benefit from that higher education in the K through 12 system. So that's an issue that I think going forward we'll also have to consider. And of course, the most vexing issue is if you agree that parents involved is dispositive for the plaintiffs in this case, then what do you do? How in the world do you really think about equality?
Thank you. Judge Wynn.
Thank you, Chief Justice, and thank you for this opportunity. I tend to agree with my colleague, Judge Lohr, at least in terms of not being in a position right now to pronounce exactly how I'd go on this case. But I do start out at least with the basic belief that there is some agreement that, at least it seems, that there is a compelling interest in diversity. The question then becomes is how do we achieve such a thing? I pose questions probably a little bit on the outside in terms of what type of diversity you're talking about, but I view that to be the questions of the future. To move away from the how do you achieve it as to why do you seek to achieve diversity, and then why, meaning if you're seeking to achieve it for purposes of education, then are you saying that individuals, which is the premise of Brown that many, even those who supported Brown, have problems with, is that an inferior education will necessarily result when minority students are in a classroom together. There are those who have challenged that and continue to challenge that. But the basic premise upon which Brown exists, and Dean Chemerinsky pointed out the differences over the 58 years from Plessy, was that at the time of Brown, given the sociological basis and the factors that were used to fashion the law of the time, no one thought about cases of this type coming forth in the future. And no one thought at that time that saying catchphrases like race should not be a factor in the segregating schools or in segregation, we should not use race, that it would ultimately be used in cases like this where you would say, well, you shouldn't use race to achieve diversity. And that has presented us with a dilemma in a time where the whole question comes up, well, if we assume that poverty is correlated with some form of race, then what happens when we seek to try to address the issue of disparity in spending? Is that not also race correlated? And if that's so, then can we simply equalize it by moving money from one district to the other? I submit to you one of the problems that was at least confronted in Brown, and as you deal with Brown was not just one decision, of course, was the fact that you have to deal with the ultimate issue that Cooper addressed, and that is to what extent does the public accept it? And if you recall, in Charles Hamilton Houston's whole theory was that we had to move slowly on this. And individuals do not accept certain things. And when it comes to taking care of children and the fact that moving funds from one district that happens to be wealthy to another district does not settle well if that other district then turns around and adds even more money from, let's say, private sources. Then what do? Do you bring on additional funds? There was a recent case we had out of this court, at least the Supreme Court, that dealt with public financing. That's not permitted, at least under the First Amendment, to do rescue funds of moving from candidate to candidate. So I think this case presents some interesting issues that have become more complicated over the years with cases of Washington versus Davis, certainly Planned Parenthood, in terms of how we view race and how we view it as a compelling interest and the reasons why it is such an interest.
Thank you. Judge Duncan.
It seemed to me that the fact pattern that we were given represented a conscientious effort to bring this system within the framework of Justice Kennedy's concurrence in parents involved. What we don't know, and some of the questions went to it, is have other means of addressing the problem been resorted to? Have other alternatives been considered? If they have, then it seems to me that the school system did a pretty good job of putting the plan fits within the parameters that Justice Kennedy spelled out. I tend to fall off a cliff on both sides of the problem. On the one hand, I think it's very hard for me to see how you can argue for equalized funding without recognizing education as a fundamental right, as Rodriguez says we don't. On the other hand, when you are trying to pursue the very legitimate goal of increasing diversity in the classroom, I'm troubled by the mushiness of it as a goal. If you don't have a destination, how do you know when you get there? North Carolina is one of the states whose constitution provides for a sound basic education. It is a constitutional right. And on the basis of that constitutional right, courts have been able to order that steps be taken to bring the lower wealth counties and lower wealth school districts within counties up to a level that provides each child, regardless of their circumstances, with a sound education. I mean, it's a difficult goal, but at least the weapons are there. And it seems to me that that's as it should be. Education should be, any education should be a fundamental right. And unfortunately, all the burden can't be borne by school systems. The disparities in education reflect housing discrimination in the housing market. But to the extent that there is any way that we can reach some consensus, public and private, about the primacy, the absolutely critical nature of an education in our system, then I think it's going to be hard to address the aspirational goals of having the benefit of diversity in creating good citizens.
Thank you. Judge Parker.
On the merits, I think I'm inclined to agree with the judges who believe that this plan is a reasonably tailored effort to comply with parents involved. I mean, there are features of it which I think I would be, as a, if we were actively adjudicating this, uncomfortable with, and I'm not sure how they would be handled. Maybe sending it back to have some of the features re-examined by the courts below. But by and large, I think this is a reasonable effort by school officials to address a very, very difficult problem. I suppose the statement I made masquerading as a question during the course of the very, very fine arguments we heard betrays my point of view, which I think, which is that I think after being around these issues for decades, are by and large beyond the competence of at least federal courts. We can be sure that constitutional issues are addressed. We can be sure that when we see cases like this, we try to resolve them with fidelity to the legal principles that have been established in this long line of cases. Also, to belabor the obvious, and I believe that the views I have are shared by all of you. This problem of public education, particularly of African Americans, is one of the most complicated and important, facing the country, and it's one that anyone who has an opportunity to get involved in or do something about, we all have that obligation. But that having been said, let me share two things with you that leave me. We're at a great teaching university, so the last thing you want to do is, in any sense, be pessimistic about issues. In point of fact, our country has wrestled with issues somewhat similar to this its entire history. I mean, America goes through one of the recurring conversations in this country is the dismal state of public education. So the debate we are having now and the issues we're talking about now are not necessarily new. I think probably the best study of this that I've read, Horace Mann in 1820 wrote a report to the Boston School Committee about the state of public schools in the city and excoriated. Poor people were not being treated, educated, the immigrants were discriminated against, et cetera, and all of the issues that we have rehearsed here, with the exception of the race issue, an important exception, were conceptually set out in I think, a very brilliant essay at that point. And one of the very first things that the Ford Foundation did when it was set up was do an examination of New York City public schools, and most of the issues that we have rehearsed today were addressed in this document in the late 40s. I remember when I was in school, Sputnik went up, and there was a hue and cry throughout the country about the decline in the status of public education. That's not to say that these are anything we should be complacent about. They're issues that we should all be worried about and concerned about and working about. But to the credit of this country, we have at least kept these issues in the forefront, if not with the results of the success that any of us would like. One last observation, which has always stayed with me. When I was on the Yale Corporation, we had a committee that looked at how undergraduates performed. It was called the Educational Policy Committee. What are we teaching, how, and so forth. Are we doing a good job? Can we do better? Et cetera, et cetera. It turned out that there was an office in New Haven called the Office of Institutional Assessment that just did these constant studies of who were the students who succeeded, why, what were the indicia on application blanks that really predicted success in school and predicted success in later life, and what did people who were, quote, successful major in and things like that. And I got interested in, you know, how African American students were doing compared to other students at Yale. And we had this conversation and with this wonderful, wonderful woman who ran the office. And she says, you know, the place at the university where African American students do best is at the medical school. And I found that a big surprise. So the next week, I made it a point to come up and go over and talk to the dean of the medical school about why this was the case. And he says, oh, well, I'll tell you, there are 3 reasons. And I said, what do the students who really excel at the medical school have in common? He says, number 1, they either were not born in this country or their parents were not born in this country. So we're talking about largely Caribbean immigrants and a fast increasing number of African Americans who are from Ghana and Nigeria. And he says, number 1, there were those family demographics. He says, number 2, they all managed one way or another to escape public schools. And they're not, you know, many, the families run a gamut along the socioeconomic scale. You know, now you're getting Nigerians whose parents are doctors, and Ghanaians who are just fit to go. And he says they're not necessarily from big cities. They're from, our African Americans are now from all over the country. And their parents were able to discover for them enrichment programs, which they all took advantage of. So it was, you know, the local college or community college would have, you know, science programs or something like that on the weekends or after school that they all attended, et cetera, et cetera. But they went to, you know, parochial schools or whatever they could cobble together, but they managed, in his term, to escape public schools. And I don't think the public school problem is intractable, but I just think it's going to take a lot of work and a lot of time, and most important, a tremendous amount of innovation and change. And you have to despair about whether the educational structure and the educational system is really up to that. And for example, in New Haven, there is a phenomenal charter school called the Amistad Academy. And Amistad, the kids, middle school at Amistad test higher than middle school in Greenwich. And Greenwich is you know, the most affluent community on the East Coast. So, you know, it can be done. But, you know, Amistad is run by, you know, Yale Law School Rhodes Scholar, and the students and faculty are all over it. But, you know, they have a system that can be replicated. So, you know, I think there's hope. But, you know, this is a problem that, you know, I wish I had more answers or more help, but those are my views for what they were.
Thank you. Judge Gregory.
I thought I wouldn't have enough time, but after Justice Parker, I think I have plenty of time.
Oh, they're keeping track.
First of all, we were given this is a special session of the Supreme Court because we were given an assignment to look at a little more broadly than normal and look into policy and what does this portend for school systems in general and courts. So I'm going to go beyond, the realm of being a judge, but it's a little forecasting. But in the context of this case, Yeah, we can find some language with Justice Kennedy in his concurrence, and maybe there might be some room for the school system here, but you can't escape. It's clear in the very first paragraph, he says, to make race matter now so that it might not matter later may entrench the very prejudices we seek to overcome. I think the thing with Brown is that we overcame a juggernaut, and that is legally segregated schools, and we said race has no place in that sense of segregated schools, no matter whether you have them equal or not. Classification by race, you can't do that. It's going to be very difficult, school systems, to have any kind of classifications based on race going forward if you're trying to meet your educational goals, or whether it's to have people work together and be better citizens, all those things. I think that's the message, that's the takeaway from that case. So looking forward, I think you have to focus on getting better schools and teaching children where they are the best you can. The truth of it is, going forward, I think that's what Chief Justice Roberts said in the very beginning. He thought it was rather amusing that a school that had that kind of numbers of Asian Americans and other type diversities wasn't considered to be diverse because it wasn't enough white, non-white. Well, at some point, you're going to run out of enough white people to get quality education. I'm serious. If that's the premise, you're going to run out of, you won't have enough white people to have quality schools. He makes a good point. So we do have to look at going forward that we have to find ways to teach kids where they are. Because even if we could fix it in places where there are numbers like that, what do you say to the kids who are in schools where the school is 99% African American, because that's all people who go to the school? Are those schools to be condemned forever to be inferior? No, not at all. And I don't think anyone has really made the case that single race schools alone without any kind of de jure is inherently inferior. I don't think anybody's ever made a case, because it's not the truth. But we do want to be a combined nation. We want to be better. We want to treat each other better. And we do have to look at, I agree with Justice Duncan, education must be a fundamental right if we're going to give ourselves the tools to fix it. We can't go to that fiction. And Justice Powell from that great state of Virginia always in his inimical style leaves room, because if you look at Rodriguez carefully, and I know you all have, it's a roadmap for how Rodriguez might come out a different way if looked at now. Because maybe there are suspect classifications now, because now we're labeling schools dysfunctional, discrediting them. No Child Left Behind, to give you a chit to go and buy a better education someplace else. It's no longer local. Now we have No Child Left Behind, race to the top. The federal government is entrenched in education. So the reasons that he gave why we can't do it, those don't exist anymore. But realistically, I think going forward, we're going to have to find some ways to educate those children where they are the best that we can. And race is the last resort for classification. And I say lastly, I tell young people about trial advocacy. Lazy lawyers strike juries based on race in terms of Batson. Every good lawyer should know enough about their case to know what kind of jurors you need or want to have based on the facts that are going to come out in your case. Same thing with educators. You ought to know what is needed to educate your children. And if you have to put a race label on it, that might be some ideas that you're really not getting into what we really need to do, and that is educate children in the best schools we can. So going forward, I think that the school system may have some problems on this record meeting parents involved, but great arguments. Thank you.
Thank you. Judge McKee.
Excuse me. Excuse me. De facto segregation obviously is an incredibly more difficult thing to deal with within the legal structure than de jure segregation, which turned out after a pretty intense struggle to not be that difficult in terms of the legal doctrines of getting a handle on it. It's not that way now. Dealing with de facto segregation, and again, bringing it back to the confines of this case, it seems to me what we're doing is really beating around the bush. There's a lot of discussion about Swan Swan was a case that grew out of a school district that had a history of de jure segregation. I think Justice Kennedy's concurrence kind of beats around the bush, and we can all of us come up with little things that we can say are not race criteria in order to get to a better, quote, better in terms of more diverse school system. And I will almost without exception wager you that the correlation or proxy, if you want to call that, is going to be relatively close to 1 and far away from 0 as we measure correlation statistically in terms of that factor's correlation with race. Having restrictions, and not even restrictions, but school districts who want to do this, doing things like locating new schools. Well, if they locate the new school in a certain neighborhood now, come back 5 years and look at that neighborhood, and the chances of it being exactly, the building will still be there. The chances of the demographics still being the same are very, very slim. And I agree. I think the only way to get a handle on this is to say that education is a fundamental right. In deciding this case, I would try to argue that. It's a loser right now, but I try to argue that education is a fundamental right and approach it that way. The difficulty is trying to figure out where that right comes from constitutionally. And I think probably the best argument is that it arises out of the liberty connotation of the due process clause. And you might be able, if you had a really strong record, you might be able to make that argument based upon health care, who dies earlier than, what group of folks die earlier, prenatal care, who gets it, the percentage of blacks who die prenatally as opposed to the percentage of whites, things like that. You might be able to make a liberty interest argument, but it's a really difficult argument to make, and probably, I said, it's a loser right now. A better argument, I think, would be to try to argue that, as I mentioned, I guess, to Dean Chemerinsky, that the law arising out of California versus Johnson ought to be revisited, where at the prison context where race was used to administratively segregate inmates for the protection of both white and black inmates. The argument was made, well, the burdens fall on both groups equally. It shouldn't be subject to strict scrutiny, and the court struck that down. In this context, I think what we should say is that absent a pernicious motive or a record which would suggest a pernicious motive, where the burden of some kind of racial classification falls equally, and that's kind of the rabbit in the hat, equally on both groups, then there's no need to impose strict scrutiny, and we should do, if not rational basis, then heightened scrutiny. That would be one way of, I think, trying to preserve these programs. Absent that, I would just have to argue that this program does satisfy the compelling state interest test. The compelling state interest in diversity has already been established under Grutter, at least today. What is this, October 13th? As we sit here today, it's still a compelling state interest. Coming back in June, that may not be the case. I don't know. And I am a bit troubled by the least restrictive means here, but I would probably be inclined to say that it is the least restrictive means. I mean, arguably, you could try a lottery and those other kinds of things, which just seems to me to be kicking the can down the road when they all don't work, and they probably won't work. Then this test would be okay. So I'd be inclined to uphold it based upon strict scrutiny. Well, I just mentioned one other thing in terms of the importance of having someone you can relate to, and that's the importance of diversity in education. A good friend of mine, who's one of the leading criminologists in the country, I had a brief meeting with him. He used to be on the Pennsylvania Sentencing Commission when I chaired it, and he was talking about a fascinating set of FBI statistics that came out right after Obama's election, which showed not only a statistically significant, but a very stark drop in the amount of arrests for black males for violent crime nationally. And I said, well, Al Bloomstein, and I said, well, how do you explain this? And he said he called it the Obama effect. And he was trying to get more statistics. I haven't talked to him since then. I don't know if that trend perpetuated or not. His theory was that there was something about, in the most crime-prone group, which is unfortunately young black males, being in a situation where they saw someone who looked like them, who could reflect a positive image of a young black male family man, that it may well be that that circumstance in and of itself was spilling over in terms of how conflict was being resolved on the streets. He said they wanted to get more data. Again, I don't know if he's gotten data to corroborate that or not, but if it's true, and it's a big if, it's a huge if, it does say something which underscores even more the importance of diversity in the educational context, especially in K through 12.
Thank you. Judge Edwards.
First, I would really like to thank the advocates, Dean Chemerinsky and Judge Professor Gertner. For those of you who are not in our business, they did a terrific job with this on a spare record. And can we thank them again, please? I just want to give you, I'm not going to vote. For me, I don't feel comfortable trying to vote on the case because there would be more in the record if it were a real case. I'll just give you some impressions that I have, having listened to the arguments and thought about this. The thing that it should show you, and it should cause you to have great sympathy for us, that is judges, solving tough social issues and applying legal principles is not easy. And this is an area in which you see it starkly. Brown, in retrospect, was not, in my view, a very hard case as a matter of law. There were hard social issues. The legal principle really is not tricky. State-enforced segregation discrimination is prohibited. That just doesn't seem like a wildly tough question for me. And I realize there's been lots written about it and people suggesting that how did we get there in Brown? I don't think it's really hard. State-enforced racial discrimination or segregation is prohibited. That's not what we're talking about here. Now we're talking about courts strapped by demographic realities, trying to find a way to get equal opportunity for black and white students. And that's really tricky, and in a lot of cases, we're out of our element because these are policy questions. They're very, very difficult, and it's hard to pluck a legal principle and say it fits. And so the answer is X. And I think you saw all of us up here struggling because the answers don't easily come. I think if you had to look at the legal question here, and if I had to decide it, I'd probably worry about whether or not the school had shown the least drastic means, assuming I could tease something out of the Kennedy separate statement and tie it with the dissenters. I'm not sure the school district showed least drastic, if I have to do it as a legal matter. But I think, as I listen to all of this and I think about it, I believe, these are my personal views now, I believe that all students, white and black, are better off, as is society, if we have diverse schools. I just strongly believe that based on my experience. Can I prove it? No, but I strongly believe it based on what I've seen and what I've done and where I've gone to school and the people with whom I've interacted. I also know that blacks have not fared well in society generally if we are excluded from or limited from diverse institutions. Not because we can't educate ourselves. That's not the question. We can educate ourselves extremely well. When I was a youngster, and my first wife was in the Washington, D.C. schools, which were segregated, they were really good schools. And those kids were really smart. They were all black, it was segregated, and they were turning out some really smart people. But those smart people did not have a full opportunity in society. They were excluded from the top positions in society. I have seen that play out over and over and over again in our society. And that's why I fought like crazy when I became an adult and had to battle to get blacks in law schools. I wanted blacks in the elite law schools because I knew that meant if you went to the elite law schools, you had opportunities to be in the major places in society where decisions are made. That's what this game is all about. We want to be, in my view, in these diverse settings because the playmakers are in these white settings. We need to be there too. And that's what this is about. It isn't whether we can find teachers to teach kids in black schools and teach them well and then test them and say, gee, they all got 100 on the same test that white kids got. That's too short a view for me. It's too narrow. There's much more going on when you're talking about diversity in education. I also think it just makes people better. You're more understanding to hang around with people who are not like you. I think that's a good thing. And I was lucky. I saw it a lot. My kids did, and I think it's a good thing. I grew up, as I heard today from the members of the Little Rock Nine, being taught that education is crucial. You better not come home with a B. And that was my sense, and I believe strongly in education. I came to understand that diverse education enhances that view, and I strongly believe that. The problem is, as my colleagues have already said, the public school systems, not all of them, but across the board, are a mess. And blacks who now have money in these cities, they're trying to get the kids out of the public schools. I'm looking at my own city in Washington, D.C. Those blacks who can afford not to go to the public schools are not keeping their kids in. They're trying to get them in the private schools. They want them in a diverse setting because they think it's going to give their kids a better opportunity. That's a really sad thing that we continue to struggle with it. And the problem we have, of course, is race, demographics, poverty are impeding educational opportunity. And I can tell you honestly, as a judge, I wish I knew what the answer was. I tried then to write the opinion to make it right. I don't know what the answer is. I've read a lot of stuff. I'm not convinced that just spending more money, I think there's studies that say just spending more money isn't necessarily going to do it. Yes, we should spend money, but that isn't guaranteeing that the product is going to be right or the kids are going to be stimulated or we're going to get the right teachers coming into the schools where you're spending more money. You know, it's not that easy. I don't know what the right answer is. And I do know as a judge, there's not an easy way for me to determine how to solve the social problem, which is the public schools, with the legal principles that are now in place. I don't have that answer. I wish I did, and I'm a pretty confident guy, but I don't have that answer. I don't know how we do it. But I know that those of you who are in other fields and are developing the policy, we really need for you to figure this out. And the burden is on you to try and help us get this right.
Thank you. Thank you. Thank you. Thank you. I can't say much about the case because we have things involving this in front of us, so I won't. And instead, I want to make three remarks. One I'd say as a judge, and one I'd say as a person, and one as a person who is here today, a spectator, if you like. And as a judge, this has been an amazing day. I mean, from beginning to end. And as a judge, I teach the Little Rock. I mean, I tell kids about Little Rock, and I'm trying to make a point about judging. Unfortunately, it's my, that wasn't your problem, really, but that is my problem. And I want to tell them something about being a judge, because I absolutely agree with what Harry said. I grew up then. I mean, you had to be an idiot not to know what was going on in the South, and not only just there. I mean, of course it violated the law. I mean, it said equal protection to law. That was passed for a reason. And that you had to be blind or something. So everybody knew what it was, and the law was pretty clear. Maybe that's hindsight. Maybe it is, but there we are. We are acting with that hindsight. But the problem was getting it done. And that's not a legal problem. That's a social problem. And so, of course, I like that case, because what I say, and I contrast it with the Cherokees, where they kicked all the Cherokees out and sent them to Oklahoma, and even though the Supreme Court held the contrary, you know that one, that John Marshall made his decision, now let him enforce it. That's what the president said, sent the army, and they went right by Little Rock. And the tribal chief, Chief Ross, his wife is buried 1.5 miles from Central High School. So I contrast that with the Little Rock case, because what I want to say there is, I don't know what Eisenhower was thinking. I don't know his psychology, but I've admired what he did. And what he did was he sent those paratroopers. And everybody knew who they were, the 101st Airborne. Everybody knew. They were the heroes of World War II, and he did it deliberately, because he knew every single American would know those are the people who got hung up in the parachutes in Normandy and in the Battle of the Bulge. And, of course, he did that. And when I tell audiences, high schools, they cheer at that, okay? They cheer. And then I have to tell them the next sentence. And the next sentence is, well, Eisenhower had been warned by Burns. He said, Jimmy Burns, he said, he was always fighting Jimmy Burns, but he said, if you send troops, you'll have to reoccupy the South. That was wrong. But he said the best that could happen is they'll close all the schools. And nobody will be educated. All right, but he sent the troops. And what I like to say about courts, you see, is Cooper v. Aaron gets up there, and all 9 judges signed that opinion. They signed it. That's almost unheard of, that 9 justices signed the opinion. And I'd like to say to the audience, yeah, 9 justices signed that opinion. We really mean this. And it reaffirmed Brown, and it said, you do it. You can't get out of this. Do it. Yeah, and the next day, when they announced their opinion first, the day after they announced the opinion, they closed the school. Okay? So then it ends on sort of a downer, doesn't it? And I want to, and it was closed for a year. And then, all right, I say, but I now still think that was a great thing because you couldn't stop it after that. You could not stop it. But what it took was a lot. It took not just the 9, it took the Freedom Riders and it took the Martin Luther, it took a lot. It took a country dedicated to the proposition of we're going to enforce this. And that means a lot of people. And they aren't all judges. You see? And that's what I want them to see. And what the judges got out of that is people now breathe in like they breathe the air that we ought to follow the law. And they believe that in those audiences, you see. So that wasn't a segregation-related benefit. That's a society. I mean, you know, that is a gain for the judges and for the rule of law. So that's what I think about this as a judge. Now, as a person, you have a unanimous panel. I mean, this panel thinks, of course, education is not only that it's correlated with race, the expenditure here, but this is our greatest problem. There isn't one person who doesn't believe that in this room. Of course it is. Now, you can say, well, what is it that I heard this morning, which I didn't know? I heard quite a lot I didn't know. And one thing I heard was, this is me interpreting, not you saying, but I mean, I've always admired one thing Nancy Reagan said. She said, you play the hand you're dealt. And they also said, we saw the opportunity and we took it. Wow, good. We saw the opportunity and we took it. And then we persevered. And that to me is philosophy. I mean, I'm sorry, that is philosophy. And so I heard that over and over. And I thought, yeah, that's right. That's where we're going to be on education. And I thought, well, do we have anything in our favor? As the law was easy, here it's hard. Here it's really hard. So I don't know if the judges are going to solve, and even in part, this problem. But I do see, and this is maybe ridiculous optimism, but I see one optimistic feature here. And I'll tell you what it is. It may be just unique to me, and it may just be my own psychology. But when I was, at the time they had apartheid in South Africa, when that was legal apartheid, and there was a big effort to get this to end, I saw one day on television a picture from South Africa, and they're interviewing a black woman about 26 years old who's walking up the street, and she might have been a student, maybe she was a businesswoman, I don't know. But they said, well, what do you think of this apartheid? She says, you know what? She says, we have a situation here that is not normal. Yeah, good. That is a good sign. You know, that is a good sign when people start thinking not just how awful it is, but it also isn't normal. And then maybe it'll change. What I see as a possible asset here is I think the vast majority of Americans at this moment, maybe you ask them what the problem is, they're going to start saying education. And you start pointing out that there is this tremendous discrepancy and talk about we are a democracy and we have human rights and we are rich as a country, comparatively speaking. They're going to start thinking, and they more and more are thinking, this is not a normal situation. So as a person, I think, yeah, that's right. This is not a normal situation. And there's a part should in there, and there's a part is, but yeah, all right, that's good enough. And then we can get going. And so I'm optimistic, and I don't know, of course, the answer to the technical part, except judges may play less of a role. But that doesn't mean the problem won't be dealt with. And the more we think it isn't normal, the better. Now, as a spectator, what do I think? I think, thank you very much. I thank my colleagues. I thank all the participants. I thank Charles Ogletree and his staff who put this day together. And I thank you all very much for coming. It was fabulous. Thank you.
Thank you. Before the justices leave, just come up here. We're going to take one picture up here if you can come up here. Come up here. Yeah, the whole board. Let me just say this in conclusion. 3 things up here. There will be a reception for those who can stay. It's in Wasserstein Room 2019, and all of you, if you go down to the first floor, you'll find out how to get that. The second thing, this program that was taped today will be on our website at noon on October 31st. Wednesday, October 31st, it'll be available for those who have not seen it yet. And finally, please join me, folks, in thanking all of our participants in a great program today, if you would.